CryptoFed's distribution of its lock governance tokens to contributors within the state of Wyoming, parenthesis, intrastate token issuance, end parenthesis, comma, free of charge, comma, without a registration filing, comma, violate any Wyoming statute, regulation, or any binding precedent under the jurisdiction of the Secretary of State's office. We have declined to answer for a couple of reasons, one of which is they have pending action in front of the SEC that might weigh in on this, and we do not feel like we are in a position to attempt to muddy the waters with that. However, since we are here now, I will give some of the summary comments I have. Now, these are not fully fleshed out, and they are not. They should in no way be read as a letter or a binding opinion, but these are, we'll call them thoughts. I'm not providing legal advice. And this is just a high-level analysis that I believe the SEC would also go through. But first, they call their token a governance token. Okay, so in a governance token, that means it is not a utility token. It is not a consumptive purpose. So that Wyoming's utility token statute is not applicable. Okay. Second, they're talking about doing it free of charge and intrastate. Obviously, their intrastate issuance is an attempt to remove the jurisdiction of the SEC because they are interstate commerce, and we don't need to get into the vagaries of Wicker v. Filburn and all that. Suffice it to say, assuming that intrastate issuance shields them from the SEC, we can move on and say, under Wyoming law, there are two aspects that we look at for the understanding of a security. One is the Howey test. So, in starting out with the Howey test, is their token a security under the Howey test? And as I said, we only have a limited amount of stuff to go on, so this may be somewhat inchoate, but their analysis revolves around the investment of money prong of the Howey test, saying that they are giving them away for free, and therefore it's not an investment of money. Later in the letter, I did not quote this, but later in their letter, they talk about how this issuance is related to services that are provided by their supporters. I don't understand, and I don't have a full understanding of what those services are. They did say related to services or things rendered, not money. The purpose of the Howey test is to determine if a particular construct or investment contract is a security. The test, as originally stated, is a contract or transaction or scheme whereby a person invests his money in a common enterprise and is led to expect profits from the efforts of the promoter or third party. We agree that CryptoFed, under the proposed scheme, the contributors do not invest money by providing fiat or other assets in exchange for locked tokens. That was a quote from their letter. We disagree with the relevance. Under Howey, while the test did mention that investment money as a prong of the test, this definition, quote, embodies a flexible rather than a static principle, one that is capable of adaptation to meet the countless and variable schemes devised by those who seek to use the money of others on the promise of profits. That is SEC versus Edwards, Supreme Court 2004, quoting Howey. The flexibility has been interpreted to incorporate situations where the investment of money is any exchange of value, which would include compensation for services or other value provided to the issuer. Hocking v. Du Bois. This explains that a exchange of value satisfies the first prong of the Howey test, and that does not mean fiat specifically. CryptoFed admits that the distribution of locked tokens will be to those who, quote, have made, comma, are making, and will make non-monetary contributions, end quote. The token distribution clearly is being made in exchange for some value received. Therefore, we do not agree that the first prong of the Howey test is avoided by their free of charge distribution. Okay, second, under Wyoming statutes, so Wyoming does read in the Howey test. However, a little bit more interestingly, while the Howey test is instructive, it is not fully dispositive on its own. CryptoFed also falls under a direct application of Wyoming statutes, specifically 17-4-102A28, I think, XXVII. A security includes an investment contract, which itself includes both the Howey test and also, quote, an interest in a limited liability company. The Wyoming Dow is merely an instance of a limited liability company. An interest in a limited liability company need not be economic in nature. It is extremely common practice in the LLC world to classify membership interests, resulting in the bifurcation of LLC interests into voting, governance, and economic rights. CryptoFed has explicitly defined their lock token as a governance token, which seems to imply that there has been at least some severing of the economic interest. Even a total severing of the economic rights does not save the lock token from 17-4-102A XXV III. This is both because the voting rights are themselves an interest in the LLC, which satisfies that provision, and also because through application of those voting rights, the economic rights can later be recombined. So since the lock token is a per se security, at least under this analysis, then we turn to their free distribution. Clearly as above, exchanging the token in exchange for services rendered is not free of charge, since that is just merely a payment. Therefore, as proposed, that distribution would be viewed as a constructive sale. Were CryptoFed to abandon a system of providing the lock token in exchange for such services and instead attempt a generally free distribution unlinked to any services or contribution, you could view that as an airdrop. So completely unlinking and severing the token from any services rendered, we'll call that an airdrop. Several instances of this have been addressed by the SEC, demonstrating that the value received by the issuer may simply be the creation of a secondary market in said securities or tokens. As CryptoFed has explicitly laid out in their plan, their idea is for the recipients to create a secondary market for the lock token. They have admitted that the airdrop is not without the exchange of value, or not without this type of exchange of value. And this goes under SEC v. Sierra Brokerage Service. Yeah. Quote, where a gift is followed by widespread downstream sales of those securities, those would-be gifts may be characterized as a subterfuge to evade registration. Therefore, the Wyoming Secretary of State does not believe that, as requested, we can issue a letter or a notice of that they are free to operate without registration under our statutes. Thank you.
Thank you, Mr. Crossman. Committee members, any discussion or questions for Mr. Crossman? Mr. Co-Chairman, go ahead.
Thank you, Mr. Chairman. And thank you, Mr. Crossman. And to be clear, that's what we needed in the first place. And you still officially haven't, based on your testimony, you still officially haven't given that as a response, but you're providing that feedback. The concern that I have and that I think we have is we don't want to be Gary Gensler and the SEC. We don't want to be opaque in our rendering of decisions. And I don't want to get into who's right or who's wrong or the analysis in any way. This is not the forum for that. But if you don't provide a response on behalf of the state of Wyoming, then we are no better than the SEC. We are no better than what we've seen with the Federal Reserve, where it's just an open question mark where we could try and act, but will we actually be in violation of the law? We're better than that in Wyoming, and I would expect the Wyoming Secretary of State's office to bend over backwards to be business friendly instead of providing the exact type of response that we have grown to loathe from the federal government, where there's no clarity, there's no bright line, there's not even anything to try and fix, because they won't tell you it's wrong until you've done it, and then you have to pay a fine or end up in jail, right? That's not the way to operate a state. Now, this was really helpful, and one of the reasons it's helpful is it turns out we don't have to follow the Howey test. We don't have to follow what the SEC recommends, and we can change those statutes you mentioned. But we don't even know we need to change those statutes or take a look at them until we hear that last speech that it took several letters and us to try and get involved to hear. So I appreciate that testimony, and I know that that's not the final letter, but I guess I would strongly encourage drafting that up as a letter so that the friends that we have here with American Crypto Fed can actually look at it, respond, and try and work through it with you in a constructive way, recognizing that our desire is for industry to be successful, for our stakeholders, the folks that we've worked with on this committee to be successful, and to find ways to navigate through the challenges in a legal manner instead of just say, I'm sorry, we can't answer that question. Mr. Chairman, I appreciate his thoughts.
Mr. Crossman?
Thank you, Mr. Chairman. As you saw, I couched this in somewhat hypothetical standards because we don't know fully what they're attempting to do, and we cannot render legal advice. We have asked them numerous times to retain a counsel. We can't tell them things that would be, I mean, while I personally am a member of the bar, I am not their attorney, and anyone else happening, it's a accident of history that I'm a member of the bar and in this position. If somebody weren't a member of the bar, they would be potentially engaging in unlicensed practice if they were to render this decision directly to them without them having counsel. They have refused to get counsel. We have told them numerous times that we wanted to wait and see what the SEC was going to do because that would override a lot of what a lot of this. And that with respect to the Howey test, it is an either you are if you are per se, you also are if the Howey test is satisfied. So they don't necessarily get around it just by changing that one specific statute. But that's just kind of quibbling. But at a higher level, they do need to get counsel.
Real quick on that
Mr.
point,
Co-Chairman?
and then I'll would appreciate your further thoughts. But on that point, the Howey test is based on federal law, not state law. The Howey test is an interpretation of federal law and what the SEC's obligations are. We are under no obligation to follow the Howey test. We are only under obligation in the state of Wyoming to follow our statute. You laid out a clear statute. Now, it might be convenient to defer to the Howey test, but I guess I would challenge that interpretation as being a false interpretation because your office's responsibilities are not to enforce federal law, to my knowledge, unless I missed something in statute. It is to enforce our state's laws, and our state's laws do not necessarily require that. So I guess I'd ask, why are we, well, I'll back up. We actually, I believe, explicitly include Howey test in statute, and that's the reason you would do it. But again, going back to the fact that we're not obligated to, we could strike that out from our statute and just go with a clearer test as an example of the things that we are empowered to do. But I understand that you're reading that interpretation of the Howey test. Is that accurate?
Mr. Crossman?
Yes, sir. Thank you, Mr. Chairman. Yes, the Howey test is a component of the existing statute, as is the per se aspect. So they are two separate co-equal elements.
Right. And Mr. Chairman, so I guess from that standpoint, waiting for the SEC to make their ruling, though, I would call into question a little bit because I don't care what they rule, candidly. If the state of Wyoming finds it to be legal on intrastate based on our internal interpretation, as a regulatory agency, not as an attorney, and these are two different things, we regulate.
Mhm.
We are fully empowered with regulating, and you're not held to legal responsibilities as a regulator. I mean, I can't imagine having this conversation with our Department of Environmental Quality where they say, I'm sorry, we can't tell you if you are or are not polluting this water until you bring your attorney in. They don't have that conversation. I've served on the Minerals Committee for 14 years. Nobody ever needs to bring their lawyer to show up to find out if they're polluting the water. The DEQ will show right up and let you know whether you're in exceedance or not. I'm struggling to understand why our Secretary of State's office is interpreting their responsibilities as a regulator when it comes to securities in a different manner where we can't just be open and direct with our interpretation of law, where we say, we see this as a problem, And if you don't agree with us, your remedy is going to be, and I'm not sure where your remedy is, whether it starts off in administrative procedures as your first remedy, I don't know, or whether you go to court as first remedy, because I don't know those statutes well enough. But one of those two things is true. So you provide a regulatory interpretation. You say to them, I'm sorry, we say no, here's our reasons. And then if they disagree, either administrative or directly to courts, one of those two is the next process. How is that not the process you use?
Mr. Crossman?
With respect to this issue, I believe, Mr. Chairman, I believe the deputy and the Secretary of State had determined that it would be too much of without them getting counsel, we couldn't advise on this because of the rapidly changing area of law on the federal level and at other levels. We had requested they get an attorney pretty much every time we talked to them, and they never brought one in, and we couldn't we couldn't put that down on paper until. But we did have frank conversations with them saying that we believe that what you're doing is a security. And they were told this. Yes, we did not write an opinion, but they've been told this numerous times that we believe what you're doing is a security.
Mr. Co-Chairman?
No, and again, I'm okay with that concept. I don't want to get into the findings of fact, so to speak. I want to get into the process, which is what we really see. And from a process standpoint, I guess I'm questioning the process that's being used, and I don't think you wrote the process. So maybe this is something that we follow up on and you explore a little bit further. But this is not how we regulate in the state of Wyoming. We're direct and we write things down. If somebody is in violation of a statute, it isn't an advisory opinion. It isn't engaging with attorneys in a dark room someplace. It is we deem this to be in compliance or out of compliance, and then there is a fair due process thereafter, and you've denied them due process.
Mr. Crossman?
Well, yes, Mr. Chairman, to be fair, they haven't done anything yet. I mean, we still don't know what they're doing. So, I mean, when we offered them the sandbox. We offered them, there's numerous other avenues. We just register as a security. In Wyoming, that's not a big deal.
Mr. Co-Chairman?
Yeah, Mr. Chairman. But again, and I'm, putting on, we both serve on Minerals Committee and we have for quite a long time. We're a little bit new into the regulation. I think particularly we don't spend a lot of time regulating securities at the end of the day. There are not a lot of intrastate securities that take place. So I understand this is a little bit new. We regulate the hell out of oil and gas. And so I watch it from the Minerals Committee, and it would just never be done this way. It just wouldn't. When somebody is starting a new operation and they are worried about air quality, land quality, water quality permits, they don't build it and then find out if they're in violation. Never happens. They go into the Department of Environmental Quality. They work with they're assigned specific people that are experts in that area. They sit down, they talk it through. They prepare their permit application. And that's not done yet. Then they bring the permit application in, they revisit it, and they say, well, I don't understand what you mean with this. This could be a problem. This might lead to a denial. They do that a few more times. They even bill for it in some circumstances on an hourly basis because everybody knows that time is money. So they've got a business process built in. But at the end of it all, you've always got a clear answer. And before you build it, you know whether it's compliant or not if you build it to spec. 100% of the time, nobody would invest in an oil and gas project that was a question mark. This might be legal, but we're not sure, and we're going to have to build it first before they'll tell us. It's never happened in my time in the legislature, and I can't imagine in the last 100 years it's happened in the state of Wyoming. So I know that the state of Wyoming is new to making decisions associated with securities this might not be the first one. And I guess what I would say is we need a business-friendly process that doesn't refer them to the AG's office, that doesn't require an attorney, but that just has a process where you can get a decision and you can get some cooperation, recognizing that we want to be business-friendly and not Gary Gensler. So I'd ask you to feel free to comment. And you also had some further comments that I cut off a few minutes ago. I didn't know if you want to get back to them, but
Mr. Crossman?
Yeah, Mr. Chairman, I don't recall what I was saying
No
3
worries.
minutes ago. But I think at this point, I can just stand on the comments I've made so far.
perfect.
Committee members, any further questions? The Secretary of State's office on this matter? Seeing none. Is there any online? Thank you very much, Mr. Crossman.
Thank you.
Let's continue on with the public testimony.
He's public. I recognize it.
The chair grudgingly recognizes Mr. Lindholm. Please proceed.
Thank you, Mr. Chairman and members of the committee. Mr. Chairman and members of the committee, Tyler Lindholm with the State Director for Americans for Prosperity, and I am testifying on behalf of Americans for Prosperity. When we look at regulatory hurdles and we look at how we build out the future and how we embrace technology and how we let people kind of self-grow and these companies being welcomed here, I first of all applaud Chairman Rothfuss's comments. No other industry would see this in the state of Wyoming. I did want to touch on a couple of things because I do think they have merit and I do think they're important, having been part of this group of people that helped build out specifically utility tokens were mentioned. The first iteration of kind of looking at Wyoming's uniform security law is not built off of, Chairman Rothfuss was correct, is not built off of anything federal. It comes from the Uniform Law Commission. And the Uniform Law Commission drafts their laws by each state is allowed two appointees to this Uniform Law Commission, and they're usually really smart individuals that happen to be attorneys, and they get together and they put together these different types of licensure agreements and what have you. Wyoming took our uniform law on security and amended that around tokens. And then later we re-amended it, calling it consumptive. In that manner, Mr. Chairman and members of the committee, I think it's important when we talk about legislative intent also. I heard that a governance token is clearly not a utility token or a consumptive token. Well, Mr. Chairman and members of the committee, if you read the definition of a consumptive token, it's fairly broad and it's fairly wide. And that's for a very specific purpose because we could not understand or completely know the intent of every token. It's impossible to know what that's going to look like. And so do I think that the governance token in this situation meets specifically the requirements under Wyoming's law? Well, I haven't read every piece of literature written on that specific governance token, but Mr. Chairman and members of the committee, it comes pretty close. So I do think legislative intent has merit there. And a lot of you have gone down this road. I look at you, Senator Furphy, when you served in the House, we were putting that together. Mr. Chairman, Chairman Western, you were there. Chairman Rothfuss, you were there. Representative Andrews, you were there. Everybody was involved on this. And so I took umbrage when I heard that that's not what it is. It clearly is. And then, Mr. Chairman, you talked about due process and how that's effectively not being there. If it was the intent and of course the implied consent of the regulatory agency and the individuals that operated within them, that you have to find an attorney before you can seek regulatory relief. Mr. Chairman, members of the committee, not only are we not SEC and Gary Gensler, but we are not New York. The fact that you've got to find an attorney before you can seek regulatory relief from a Wyoming agency is beyond the pale. And nobody has warred with the Wyoming Secretary of State's office more than I have in the last 10 years. Now, granted, not under this new Secretary of State. I've been relatively quiet. But the fact that we are now sitting in a place where you've got to have an attorney before you can seek regulatory relief in the state of Wyoming flies in the face of everything that we hold dear here in the state. And Mr. Chairman, I don't know if you're planning on drafting legislation or if it's too late or not, but that clearly something needs to be done if we have an agency in the state of Wyoming that is denying a corporate citizen from seeking regulatory relief. And with that, I'll stand for any questions.
Committee members, any questions for Mr. Lindholm? Anybody online? Not seeing any.
Mr. Chairman,
Mr. Co-Chairman,
and I'll just note that, Mr. Lindholm, how many years were you chairman of the Corporations Committee?
Mr. Lindholm,
Mr. Chairman, 4 years,
And then served on it
Co-chairman.
for how many years?
6 years, Mr. Chairman.
Right. So
Mr. Co-Chairman.
when you say, Mr. Chairman, Mr. Lindholm, when you fought those battles, then you were fighting them on behalf of the people of the state.
Correct, Mr. Chairman.
Lindholm,
Yes.
Thank you.
Yeah. Mr. Chairman, also, if I could really quick,
please proceed.
if the intent of an agency is that you must have an attorney present before an interpretation can be made, what would be the point of having a uniform law? What would be the point of having any of these laws or regulations in place, if not to seek regulatory relief, if not to seek the opinion of the agency? What would be the point of having those regulations and laws in place?
Yeah, Mr. Lindholm, I would add on to that, look, you need an attorney when there's a clear or even alleged civil violation. If there's no violation that's being alleged, either in writing or otherwise through filings, what's the point of having an attorney? So I think that point is well taken. Committee members, any further questions? Seeing none, thank you very much.
Thank you, Mr. Chairman.
So still a public testimony on this topic that's really been, let's just wait for just a minute and give other folks a bite at the apple, just in case. Yeah, Mr. Duccini, please come up.
Mr. Chairman, Mr. Co-Chairman, committee, thank you for the opportunity to speak. In years past, I think this is our 5th year coming, and this is just an absolute privilege to see how real democracy can happen and function. We come from Minnesota, part of the Silicon Prairie, and I'm pleased to report that we have re-domiciled our broker-dealer out of
Real quick,
Delaware.
could you just state your name?
Oh, sorry, David Duccini,
Thank you.
founder of Silicon Prairie. So I'm pleased to report that because of the Chancery Court, we've re-domiciled our broker-dealer out of Delaware into Wyoming. So that's one less for them and one more for you. I had some thoughts a little bit about kind of what the Secretary of State has said, sort of with regards to this migration concept and the lack of a will thereof. So just as a quick background, I'm kind of a financial technology nerd. I accidentally became an investment banker. I've been writing software since 1980. I'm 56 years old. I've seen all sorts of migrations happen over the years, mainframes, green screens, going to web-based systems, screen scraping, APIs, etc. So I personally hold many series licenses. I'm uniquely qualified. I've written blockchain-based implementations. I have a dozen patents on blockchain for Wells Fargo. The API itself, in theory, I agree. The data structure, the underlying schema is critical. To date, I don't know if the existing system supports, but I would think a reasonable first step would be supporting XML uploads. And that is something that the SEC supports through the XRPL. So I would think that would be a natural, easy first step where you could create essentially a proxy or a gateway, if you will, that could ingest those. That could be done securely, under authentication. So I don't know if that's been brought up or considered. I don't know if that's even available, but I would consider that as a first step. Regarding the comment about bad policy, I think vendor lock-in is bad policy. I'm just going to say it. I think, being beholden to a single vendor, puts you in a perilous condition. I've had personally situations where I've been canceled by banks. I've had situations where we weren't able to get services, and it's incredibly fragile and risky to have a vendor lock-in. The data belongs to the people of Wyoming, fundamentally. I mean, I don't know what this system is written in. I don't know what's based in. I'm pretty sure you could probably extract it. I'm pretty sure you could reverse engineer exactly what's going on just by looking at the screens alone. And the existing system must be maintained for QC purposes. I mean, it would be irresponsible to try and do a lift and load, right? You got to be able to garbage in, garbage out. You got to see if the new system is going to behave at least to the de minimis of the existing system, and in theory, provide better, access and functions and functionality. And then lastly, I would just like to propose that, the U could create and lead an open source project where this open source system could not only just be open source, but could also be licensed. This could be a source of revenue. And there's lots of precedent for that in other universities that have created essentially the backbone of the technologies that we use today, everything from the humble web browser to LDAP services to email services. So with that, I'll take any questions.
Thank you, Mr. Duccini. I think the open source idea, I mean,
Yeah.
it's not novel. We know it works. There's lots of proof of concept. I think that's a really good suggestion that quite frankly should be more explored in depth. Committee members, any questions for Mr. Duccini? He's been a fervent advocate of these issues, and their attendance is excellent at this.
And we're happy to see both of you back.
And we're
Thank
happy
you
to see
so
both of
much.
you back.
Yeah.
Mr.
Of
Chairman.
course. Yeah, any questions? Seeing none. Is there any, I don't think was any online, Clarissa? We're certainly not A&I, but why don't we just hire right here, right now to do these things?
I would largely do it for free. Just for the sheer pleasure. Just for the lulls.
Well, thank you very much for your, sorry, go ahead, please. Yes.
Hi, I'm Jade Barker. I'm also with Silicon Prairie. I would share a few thoughts as we were giggling in the background. So we have a suite of financial technology companies, like David said. We brought the broker-dealer to Wyoming for several reasons. Mostly the great work you guys have been doing is really attractive. We think of states as vendors to companies, and we've picked you guys as a vendor to us for good reasons. We had a terrible time with the Minnesota Department of Commerce. They had some similar sort of attitudes about, well, we don't have to tell you if you're about to break a law, that sort of stuff, literally pushed us into the arms of another state. So I have some thoughts on that. Again, if you're going to just abdicate your responsibilities, why do people like us need state laws at all? We would just wait on the SEC. What do we need you for? And it's a little bit in the software half of the world, a bit of a denial of service. And that's the opposite of what, businesses are coming for. I did want to say a little bit about the software. Not having a request for proposal automatically looks like a conflict of interest. I don't even know these guys, but that doesn't look right. That doesn't smell right to me, just as a personal, the vendor lock-in. So yeah, David has actually written software for our own company. We now license our software. We're not trying to get a job here. We have plenty of our own stuff to do, but we would throw in some free time to help advise on this stuff, just because he is a national expert in both blockchain and software security and banking software. So it wouldn't be that big a deal. We already have a platform ourselves that has handled $50 million. We do APIs. We know all that stuff. So if you just need one outside person to throw some thoughts on there, we're happy to help. And then I did want to, circling back to, do you need blockchain for this stuff? Yes. So in the transfer agent, not everybody's familiar with what a transfer agent is. They keep the registrar of who owns what in financial securities. And so having a tamper evident seal on records is a huge deal because those records later on become forensically important. And especially with cryptocurrency, I'm starting to see people that have issued a financial security on a chain that has later been popped. Just being able to have those records in good condition for later court purposes matters a lot. And nobody's going to ask for that out of the gate. Just like as a business, I want to have court problems later, right? And then specifically, there were some conversations about cybersecurity earlier. Yeah, it's just plain more secure to have that higher level of things. And then my last point, because I know we want to manage time, is specifically about the cryptographic signatures. Also in the transfer agent division, normally in transfer agent work, they are almost like the bank tellers who stamp off if a secondary sale of a financial security may be lawfully done. And the public markets, they do something called a medallion stamp, which is a wet ink stamp that is held by the transfer agent. And it represents an insurance policy on the transfer agent as to if there's a later suit about, hey, this was not a lawful transfer, those shares were stole out from underneath me. We think that our software security security protocols are better than a lot of banks. So we're leaning ourselves on our contracts with our transfer agent clients. Hey, here's why we're not using medallion signatures. We actually think this is a more robust standard. And so having some legislative body codify that we're doing something that actually does make sense would actually help on that front as well. That's all I got.
Thank you, Ms. Berger. Any questions? Committee? Seeing none, I don't see any online. Again, we really appreciate your attendance and your valuable contributions. They're always shockingly common sense.
Thank you so much,
Thank you.
Chairman.
I think there were some other folks who wanted to, yeah,
Thank you.
please, please, come forward again. You know, the protocol states your name and who you're with. Good. There you go.
Hello, members of the committee. My name is John Belitsky. I represent Balcony Technology Group. I'm going to remove my hat, but I would like to note that it is a University of Wyoming hat that I
It is,
purchased
yes.
here.
Well noted.
Thank you.
Go Pokes.
Thank you. Thank you for having me today. I really enjoy coming here, and as I usually do, I'd like to thank you guys for your work. It is exemplary and it's invigorating to be a part of this process. I've heard others say the same thing today, and it remains absolutely true. I want to provide testimony today on two different items. Firstly, the business registry, and separately, the proposed cryptographic signature act that Representative Singh was discussing earlier. I've not read it, but I have some comments I'd like to provide. With respect to the business registry, I remain a huge advocate of bringing this technology onto the blockchain. I've heard now over several sessions discussions about implementing APIs. I'll note that I have built these systems by myself in their entirety, from the smart contracts, the TypeScript that operates what you describe as the GUI, Chairman Rothfuss, the backend Express APIs that operate all of this. I've done all of this work and am frankly an expert in this, particularly as it relates to real world assets. And my thinking on this matter has evolved substantially recently. Firstly, from a policy perspective, and secondly, from a technology perspective. From a policy perspective, it seems evident to me that the state of Wyoming's commitment to protecting beneficial owners' anonymity and the state of Wyoming's responsibility to protect against foreign interests who are potentially purchasing land in the state, holding other assets, maybe violating KYC and AML laws, they are currently in conflict. And the solution to that ought to be a blockchain-based registry that allows for these things to happen. I care not to comment on the budget, the method by which the state of Wyoming and its representatives and its stakeholders decide in concert on how to get there. But I want to underscore that this is a threat that I think is real. I don't think it's boogeyman type of, scaremongering. I believe that this is a real threat. And I believe that this is something that is solved by the technology that we are endorsing here. And I'm hopeful that the stakeholders in the state will find a way to arrive at that solution quickly. And so I want to offer that testimony. Secondly, on the technology side, I have spent a half a decade building technology like this, thinking about APIs and the blockchain as these separate things. And I've recently had a revelation that smart contracts are in and of themselves effectively APIs when used correctly, which is to say that you have the same separation of concerns where each of these smart contracts handles discrete information. They're also recursive, meaning that you can have APIs that are called against individuals scoped to their particular business or their particular interest in the state. This is a really powerful way to protect privacy and to organize the data architecture of the state that benefits citizens. And to Chairman Western's point earlier, they won't know how great it is until they're driving instead of galloping. And it will be a massive difference. And I think that on that point, that there is consensus in this room. It's just a question of how do you get there? And again, I will not comment on that at all, but I will say it's worthwhile to get there. And I think there's tremendous benefits to the state if you are able to do that. And then the second matter is the CSA, or the Cryptographic Signatures Act, that was proposed by Representative Singh. I'm concerned that the existing e-sign framework potentially does what you're wanting to do already, and that over-engineering policy like code can have deleterious effects on the ecosystem for other builders. I'm sure there's other people in this room that are ready to deploy software in this state right now that if they knew that cryptographic signatures were going to be recognized in court, they could immediately profit from software that they deploy in the state, and the state could immediately benefit, almost certainly through profit, from the deployment of that software in state. And what's interesting about the e-sign Act, and I'll pose a bit of a thought experiment on this subject, but the e-sign Act never actually described a signature as a signature. It stipulates that it must be adopted by a person with the intent to authenticate or approve an electronic record, meaning that your signature can be anything, right? Like you can sign an X, you could sign your name, you could sign initials, you could draw a happy face. But if the intent is to put forth that signature as affirmation of your intent to record this agreement, to execute this agreement, then it satisfies the criteria of the e-sign Act. And my thought experiment for the committee is, what if I were to just sign 0x0649 instead of my name, John Belitsky, on an agreement? Under the e-sign Act as it exists today, that would be a valid agreement and it would be enforced. And so if that's the case, what is the distance between the already existing e-sign Act laws and what's being proposed? Is it really necessary? And how do we accelerate the adoption, enforcement, and acknowledgement of cryptographic signatures under the existing framework so that we can expedite the deployment of software in the state that is a benefit to the state, benefit to its citizens, and a benefit to the businesses that want to do business here?
Thank you, Mr. Belitsky. Any questions? Committee, Mr. Co-Chairman?
No, Mr. Chairman, the one thought though is, I think this is something for Representative Singh and the working group to contemplate is, how much have we already got in place relative to what we need to achieve what Mr. Belitsky's talking about, where we have absolute clarity, but without over engineering it in such a way that we actually end up leading to further restrictions. So I encourage Representative Singh to work with his group to talk that through. And once again, we may have legislation this session, we may not, but I think that's wisdom, that we want to ensure that we have it right, that we, at first do no harm as the approach.
Mr. Co-Chairman, gosh, it almost sounds like we're trying to regulate to enable and not restrict.
Yeah, exactly. With clarity.
I think we're gonna get each other shirts that say exactly that. Representative Singh, please.
Thank you, Mr. Chairman. I believe we have Brendan online who has a response to this.
Yeah, well, just hang on a second. I want to make sure, Mr. Belitsky, was there anything else that you wanted to add on, or?
Mr. Chairman, no, just thank you again for having me. I would love to hear Mr. Meyer's thoughts on that if he is online.
Mr. Chairman,
Mr. Co-Chairman, please.
we are an hour behind schedule,
We are. We've got a pretty good demonstration.
and I
that
suspect we can go into the weeds on this one for a while. So I
Yeah.
think maybe we take the weeds offline
Let's.
and follow up with some internal discussion.
Mr. Maher, I really do appreciate your testimony on this. I know, but we're getting a little bit behind, and we just got to, we've got a demonstration that we've teed up. We've got folks waiting in the Zoom world that are going to give a demonstration whose time is valuable. So is it okay,
30
Brandon? if we
seconds?
Just
30
all right,
seconds.
you got a hard bargain. 30 seconds.
Okay.
30 seconds.
Okay. The first is, please, the committee, if you can consider, based on the other discussion, a compensation token, a motion to create a compensation token. That's my recommendation there. Second, to answer what we're just talking about here, yes, all of these things are what the working group has considered. I'm familiar with the e-sign Act. I also have an understanding of the way security tokens are handled by the registries that the other party was talking about. And what we are addressing all of these issues. Rest assured, we have already thought about them in detail, and this is why we have segregated these acts into different pieces. So I'll leave it at that, but we have a plan for all of these issues, and all of the people who have testified are spot on.
Excellent. Well, thank you, Brandon. I appreciate that. Seeing no further public comment, we're going to go ahead and close public comment on this. Yeah, Mr. Chairman, we still have not actually dealt with the question of the draft before us. Do we want to, I mean, given that we've got folks waiting to give a demonstration, do we want to punt that to tomorrow, or do we want to try to knock that out now?
I think we should get to our demonstration immediately, and we can even put this off to the end of the day if we have any time, or get to it tomorrow.
Yeah, that's kind of, Mr. Chairman, that's kind of what I'm feeling as well. Let's just hang on for just a sec. Yeah, Mr. Co-Chairman, I think just, we've got some folks whose time is valuable that have got a really cool demonstration for us. And so my inclination is let's get through the demonstration here, if they have to say. If we have time at the end of the day, we'll deal with this question then. If not, we can also tack it on to tomorrow's agenda, and maybe we can order pizzas or something during lunch. So that's kind of,
Okay.
Absent any objection from the committee.
Ian objects to the pizza, but not the decision otherwise.
Okay, all right. All right,
It's
well,
fine.
okay. So with that, we're going to move on to our next agenda item, and we're only 1 hour behind schedule, and that's artificial intelligence. I know we've got a couple of bill drafts here. We've got this demonstration. So let's go ahead. Is Daza, I mean, who do we have? Are they all teed up? Okay, so we've got Daza, Alex, Campbell. We got everybody? Okay. Well, Daza, thank you very much for arranging this. We apologize for the delay, as I'm sure you were probably listening. It got pretty spirited. Really good discussion, by the way, committee. I think that's the kind of stuff that makes this committee enjoyable. But we really appreciate, Daza, all the work you put in for this. Kind of the 30-second background is that obviously AI is the buzzword. We all hear it a dozen times a day. But Daza has been really helpful to this committee in kind of helping us work through the thought experiment of how do we regulate this. Again, we want to make sure we don't go overboard in either direction with anything, and certainly AI being as topical as it is, it's something we've talked about a lot. Daza has very generously teed up some folks who have a lot of experience in AI, whether it's in the technical aspect, the legal and the regulatory. And so, Daz, I don't want to steal too much of your thunder. So why don't you take it away and kind of lay a bit of the groundwork in this demo and some of the context around it.
Thank you so much, Mr. Chairman, Mr. Co-Chairman, and members of the committee. My name is Daza Greenwood. I run law.mit.edu. And I'm also a researcher at Stanford Law School, and run civics.com, a legal tech consultancy. And in all of those endeavors, my focus is using technology for legal tasks and processes, what we call computational law. And only in the last 2 or 3 years have we really been able to achieve this goal because of the capabilities of the new generation of AI. I'm talking about large language models. And I believe that today, what the co-chairs have requested is a deeper dive into one aspect of generative AI, which may be the aspect that most catalyzes a potential need for some legal reforms. And that's because it extends the capabilities of generative AI and of AI systems in ways that increase what it can do and the impacts it can have. And there are tremendous benefits for this and some risks as well. I'm talking about agentic AI, or using generative AI as an agent that can perform a task or some sort of workflow on behalf of a user with potentially very little or no oversight or approval before it's done with that workflow. And so what I've done today is put together a couple of people who are deep into this type of technology, people who I respect and who I go to find out more about what the state of the art is. And they're prepared to provide an overview of agentic AI in particular, as it relates to algorithmic decision making and the sort of frontier of this technology and what's happening in the market. And I will provide some synthesizing remarks when they're done. First up is Alex Riebman, who is CEO of Agent Ops, and who has taught me a great deal about the cutting edge of agentic technology, and who's going to provide an overview and also some more information about what's happening in the industry right now, like who's using this technology for what. Then Campbell Hutchinson and team is going to show a live demo of a great application of this technology that is in legal context. I was able to see this demo 2 weekends ago at Stanford Law hackathon, and it basically demonstrates a regulatory process. I'll leave it at that. I'm terribly sorry that some of the people who I put together to testify the last time you asked me to put a panel together aren't able to make it today due to just conflicts in schedule. But luckily, as time runs short, this will take less time, and I think that the speakers we have are directly on point. So with that, with Chairman's permission, perhaps we can allow Alex to speak next.
Thank you, Daza. Yeah, Mr. Riebman, we really appreciate you making this effort and setting aside this time to come and chat with us and share your knowledge. Just for committee protocol, just introduce yourself, who you're with, maybe give us a little bit of background info about yourself, and please proceed.
Thank you very much. Thanks again to Daza and the committee for having me on. My name is Alex Riebman. I'm the co-founder and CEO of Agency AI. We're most well known for building a tool called Agent Ops. So Agent Ops is our primary product offering, and it's what we're most well known for in the community. So about myself, I've spent the past 8 years working as a machine learning engineer, mostly building MLOps pipelines for very large organizations, including financial institutions and cybersecurity companies. Agent Ops is a recently funded venture. We announced our fundraising about a month ago. We've been operating for about a year, and we're headquartered in San Francisco.
Excellent. Please proceed.
Yeah, happy to. And for illustrative purposes, we'll be showing off a little slide deck, and we'll kind of show off some cool demos and a high-level view of what agentic AI is capable of. So, okay, beautiful. Is my screen visible? I think it should be.
Yep,
okay,
we
awesome.
gotcha. We're tracking.
Perfect. So just a little bit about myself. So again, I'm the co-founder and CEO of Agency, also known as Agent Ops. We are essentially we're building a future infrastructure for agentic AI. So agentic AI is this idea where you basically can give high-level instructions to programs and they figure out how to solve problems on their own. Whereas in the past, we normally had to code these things ourselves. So I previously, again, I mentioned earlier before, but I worked as a consultant, did a lot of work for large financial institutions, also worked in their almost cybersecurity, building machine learning-based antiviruses. And we recently announced our fundraise a couple of weeks ago, although we're about a year old at this point. So what we're doing, and this is kind of the most technical slide, and I'll go into some cooler examples in a little bit. Agent Ops is a core dependency in the AI agent software development lifecycle. So we help developers everywhere from the prototype to the productions phase, both brainstorm, architect agents, find solutions for different problems. We offer consultancy as well as develop the developer tools that make it easy to take ideas to market. So right now, a big challenge with AI agents is that they're very slow, they're very expensive and unreliable, and we built tools to help build a curated evaluation cycle that make it so that these software programs, which have very ambitious potential, actually function in the real world. And the way that we do it is we have a software library called Agent Ops, and it's a 2-line of code integration. We work with most of the major frameworks. Some you may not have heard of, but it's very simple. It's just kind of like a plug-in to existing agentic software. And what we give is basically kind of an auditing dashboard that lets you see making sure that your agents are under control, that they're operating as expected, that they're within cost thresholds, and you're able to monitor so that they're compliant with your organization standards as well as any regulations. So that begs the question, though, what is an AI agent? So the easiest way I use to describe it is that at least here in San Francisco, and at least maybe you've seen on YouTube or on social media, that we have kind of actually self-driving cars. And the idea here is you give them instructions. I want you to go from A to B, right? So figure out how to navigate to this location. And an AI agent is like a self-driving program. And so you actually give it as you give an instruction, like, order me a pizza. So I don't know if any members of the community have used ChatGPT before. ChatGPT is this really wonderful technology that can answer questions. It can read poetry. It's extremely knowledgeable, but that's what it's fundamentally limited to: asking and answering questions, or answering questions. An AI agent is actually something that can change the world state in some degree. So you can actually say, "Hey, order me a pizza," and it will take a credit card. It will get a phone. It will get an email, and it'll actually place that order for you. It'll call a representative, and it's all a program that's doing that. There's no humans in the loop whatsoever. And that's really kind of the power here. You have these self-driving programs that we're able to program ourselves. And what they've been what's happening is this is all kind of stemming from this boom in large language models. So OpenAI released ChatGPT in November 2022, and since then there have been a number of projects that picked up early 2023 that really build upon this technology. So a few very large ones are one known as AutoGPT, which was essentially a project where a developer had prompted ChatGPT to keep improving itself to the point where it became nearly fully autonomous. So instead of having a human in the loop constantly guiding and instructing it, it would actually build its own software. And at that point, it became one of the most popular projects on GitHub. GitHub, for those not super aware, is one of the most popular, actually the most popular open source software community on the web, where people share projects, they work on community efforts, products, so on and so forth. So 80,000 stars is it's probably one of the most popular projects of all time. And same thing goes for a number of other projects from Microsoft. A company called Reworked created one called Agent GPT, and a famous investor named Yohei Nakajima created an AI agent called Baby AGI. They all function with a similar premise, which is you essentially have software that learns how to build itself. So what exactly does that look like? And it's really kind of hard to explain without showing off a few examples at the very least. So a very, very cool example is one called Voyager. And Voyager is an AI agent that was built upon the video game Minecraft. So I don't know if anyone's tried this game before, if you have kids that play this game, but essentially it's an open world sandbox game where you can actually, you as a player can interact, you can collect blocks, you can fight enemies, you can build castles, so on and so forth. And a team of researchers at NVIDIA, Caltech, UT Austin, Stanford, and ASU, they all came together to actually build an AI agent. Instead of a human playing the game, an agent could play the game. And the way that would work, and this again, if it's a little technical, I'll try to keep it slow, is you can instruct this agent to complete an objective. And you could say, chop down a tree, or create a crafting table, or fight a zombie. And what the agent does is it learns how to do that by writing its own code. So there's a scripting language that interfaces with Minecraft. The agent would write that code, and if the code was operational, it would save that code to a skill library. So the next time that it encounters, let's say, a zombie or a tree to chop down, and you give it the instructions, it can learn that skill that's already written down from that skill library and solve the problem. And what that looks like actually tangibly is here's a little video showing off an AI agent playing Minecraft. So you give the high level instruction to swim or catch a fish. And so what you're seeing right now is the agent actually playing the game. There are no humans involved whatsoever. And so you give it the high level instruction to hunt down a pig, and it's figure out how to do this on its own. And it's all because of code that it's learned to write for itself. The way that this model was trained was both by watching thousands of examples on YouTube, but also it's due to the advancements in GPT-4 that it's actually able to write its own code and operate in this way. So these are all enabled by advancements in large language models, which is really surprising and extremely powerful. We're at the very, very beginning, and this is just one example. So for added context, some use cases that we've been seeing a lot of, especially we work with a lot of enterprise users, is 4 different kind of domains. So the first domain is the AI copilots, and you can kind of think of these as the ChatGPTs of the world. So these are things from answering questions to chatting with your data. So a lot of people in this room, I'm assuming, work in law, and maybe you want to do a draft of a bill. You can actually upload your bill to ChatGPT and say, are there any issues? Are there any problems? Are there any conflicts in this bill that are worth considering? And imagine an enterprise, it's not just, public bills, it's actually private documents. Sometimes it's healthcare data. Sometimes it's a variety of different data sets that you don't want going to a third-party provider. So AI copilots, though, actually offer an enormous potential. We see a lot of adoption with those. The second major vertical we've been seeing is the agentic chatbots. So we're all familiar with this really horrible user experience where suppose you want to file a refund or change your flight ticket or something like this, and you're chatting with a chatbot, maybe a bot or maybe a human. Either way, it's not so great. But what we're seeing is kind of an emergence of AI agent chatbots that are able to instantly, iteratively decide how to solve problems. So it can refund tickets. There's a company called Klarna, which is a Swedish company. They do buy now, pay later solutions. They replaced 90% of their human support staff with AI chatbots powered by GPT. And it's bagging them about $40 million a year in profit. It's an extremely high product market fit product that they built out. On the more nerdy side of things, we do see a lot of developer tools. So there's a really interesting tool called Cursor. Cursor is an AI code editor. You give it a high-level instruction, it can actually write entire applications for you automatically, which is really interesting. Another one that came out recently is called Devin. Essentially, you just give it a high-level instruction, you give it product requirements. It can make websites, can make mobile apps, iPhone, iOS, all with one line of English, right? And it just figures out all its own how to write its own code and make software, which is really excellent and surprising. Lastly, we've seen this a lot more, and this is the last vertical before I'll kind of wrap things up, is autonomous agents. And this is where we're seeing a lot of very, very valuable use cases appear. So autonomous agents are things like, think about instead of hiring an intern or a virtual assistant, you're actually going to hire an AI assistant. And these AI assistants can do everything from scheduling, even scheduling appointments for you, talking to your doctor, speaking to customer support. They can do contract negotiation. I saw an AI agent this weekend that would go to Facebook Marketplace and then negotiate with users on how to get the cheapest price. So he was trying, this friend of mine who built this agent was trying to buy a beanbag chair on Marketplace. And he sent an AI agent to Marketplace to negotiate, and he got $50 off of this beanbag chair. So you can just imagine, like, you give a high-level instruction to these agents, and they'll do your job for you. So instead of hiring humans, we might be hiring AI agents in the future. So lastly, just kind of talking about the stack, just thinking about what AI agents are capable of. The reason that AI agents are interesting is that they're all powered fundamentally by large language models. Large language models are by and large created by large providers like OpenAI, Mistral, and Anthropic. They have hundreds of millions of dollars to train these models, but they become extremely powerful, and they're very good at answering questions. Now, when they actually become powerful, then we outfit them with tools and functions. And kind of like an interesting analogy here is that what separates humans from other animals that are intelligent, like orcas and dolphins are intelligent, is that humans actually know how to create and use tools. And so do AI agents. And so in this way, instead of just like being intelligent question answer machines, they can actually change the world state in some meaningful way. They can send emails, they can make phone calls, they can update databases. And with those in mind, you can actually create extremely powerful programs in a very short amount of time. And that's what's very, very exciting about this field. A lot of the other stuff that's coming into play here, we're seeing a lot of software companies working on all parts of the stack here. So this is kind of like the AI agent stack. So we're seeing a lot of companies working on vector databases, which are specialized databases for creating memory for AI agents. So essentially, I can tell an agent that I have an allergy, or maybe I have a certain diet, and the next time it interacts with me, it will know that about me. So instead of having to go in blind every single time, it has an understanding of who I am as a person or the context of the business. Another thing that we're seeing a lot of is multi-agent tendency, which is instead of just having one single agent, you actually have multiple agents that work together. And this is actually where it becomes a little futuristic, which is I might have a scheduling agent, but I might also have a product manager agent. And the scheduling agent works with the product management agent to basically coordinate a calendar for me on my behalf. And it's a very exciting, very powerful stuff that's coming out of this thing. So just to close things off, I'll show up a very interesting demo that we've built. So you can do this for a lot of different applications. A lot of right now is not very no code. It's very code heavy. So I apologize if I'm showing a little too much code for the time being. But let me go ahead and show off a little terminal. So here's an AI agent. It does a stock analysis for us. So we're going to just pick a stock. I'm going to run the Python program Python main.py. And what it's going to do is going to input us and say, hey, please give us a stock, and we will try to do some research. And by we, I mean the AI agents. So right now, I'm going to say, what company do you want to analyze? I will say Google, just for the sake of having Google be analyzed. What Agent Ops is doing behind the scenes, by the way, is we're offering kind of an analytics dashboard that enables you to see in real time what's going on with the agents. So right now, the agents are actually, they're working together. So I'm going to just real quick show you what the agents I've created are. Excuse me. Okay. So again, I understand it's a lot of code, but I will try to simplify it as much as possible. So let's close this guy. So I've created a crew of agents. So essentially what I've created here is, a research analyst. Financial analyst. And the financial analyst job, and it's in plain English, is to impress all customers with their financial data and market trends analysis. It has a backstory, and more importantly, it has tools. So I've actually given it access to SEC tools, so it can read and search for 10Qs. It can read and search for 10Ks. It also has a calculator, so it can actually do math on the operations that it does. I've also created another research analyst who also has access to Yahoo Finance. It has access to the SEC. It also has the ability to browse the web. So this agent's able to search the web and find information about news and understanding where the stock currently is, not just based on point-in-time data, but what the trends are. And then I've also created an investment advisor. And so the investment advisor, its job is to basically collect all the information from the other analysts and make a recommendation for us. So I'm going to go back to this terminal. Again, this is a lot of text, but this is what developers are currently dealing with. It's very, very early, very, very prototypey phase. But we can actually scroll through and see exactly what the agents are doing. So we can see that the first agent is creating a comprehensive report on Google and other recent news articles. So what it's done is it's searched for Google recent news. We can see that it's created a list of Google Chrome deadline. You have 17 hours to update your browser. Google search test recent post carousel. Oh, very interesting. Maybe that will affect the projections. From ChatGPT to Gemini, how AI is rewriting the internet. So basically a review of Google's AI product offerings. And so what the AI agents right now are doing is they're reading all this information from the web and they're trying to form an opinion with each other. Again, the amount of code I've written to create this the simulation is very, very minimal. All the agents are doing the hard work here. And what I can actually do is monitor and observe them in our dashboard. So Agent Ops, again, is a software tool that makes it very, very simple to monitor these things. I can see how much they're spending on OpenAI credits, which is I'm using, the amount of tokens I'm consuming, and whether they produce any errors, which is very valuable for compliance teams. I get a kind of a nice view of how many tools they're using. I get a chat viewer that lets me see exactly what the agents are doing at a point in time. And more importantly, we also have like kind of a session replay diagram that shows us step-by-step how the agents are reasoning through problems. So I can see, for example, here, I had a GPT-4 call that cost us about half a penny. I can see the prompt and the completion. I can see certain metadata. I can also see tools. So for example, this orange bar here shows me that we were searching for Yahoo Finance on Google. So with that said, the AI agents are eventually going to come to a summary about what the stock recommendation is, whether I should buy or sell Google. And just this point to close off is, you can basically give high-level instructions to these programs in plain English, and they will just do the work for you. And this is really the magic of these things, these self-driving programs that we're launching. And in this future, let's say it came up with the investment thesis, and it says, it has created a report somewhere. I will spare you the report. Conclusion: prevents a compelling investment opportunity with strong financial health. All right, so not financial advice. These were AI agents that gave this to us. But you can essentially imagine several other use cases. I've seen it used for making phone calls. People have built entirely customer support agent teams. We've seen people do research. We've seen people build entire companies with only a couple of people, and the rest of them are AI agents. So this is really the future we're planning. I'm happy to answer any questions, but that is my spiel. Thank you very much to everyone listening.
Alex, thank you very much for that demo. I mean, it just, every single time I get one of these things, it just, if your objective was to turn my brain into scrambled eggs, by God, you succeeded. So I really do appreciate that. Alex, kind of the process is, first we let the our committee members see if they have any questions or comments. So I want to turn it over to the committee. Is there any questions? Representative Yin, please go ahead.
Mr. Chairman, I think agentic AI is, and Mr. Redmond, thank you for the demo. I think agentic AI is definitely one of the things that people both are amazed with and are worried about at the same time. I'm curious on what your thoughts of the risks are. So thinking about the chatbot example, if a company gives a chatbot agency to give value to customers, right? Like give ticket refunds or whatever, is there social engineering risk? Like, of course, there's social engineering risk with the human being on the other side, but with the chatbot, is there increased risk in that situation?
Mr. Reedman, please go ahead.
Yeah, thank you for the question. The answer is absolutely yes, and you're very forward thinking for thinking about this because I think it's a very common problem actually that people run into industry. And so what's actually really great about just the AI agent space in general is people are security minded first when they're developing the AI agents. So there's actually a lot of companies that we've seen and also we partner with. We were partnered with a company that does LLM prompt detection, which can basically identify when a user is trying to jailbreak, so to speak, the model in a way that can manipulate it. So for example, filing a refund or getting a discount on something that's not deserved is probably a very common use case for these customer support chatbots. So building these guardrails into the models or into the agentic systems themselves is a #1 priority for agent builders in general. So a lot of these are actually, there's 2 layers. So there's actually the LLM layer. So the LLM layer, which is OpenAI, the Anthropics of the world, the people training the model are building safety in first, but also the people are building additional guardrails on top of that, because social engineering is a very serious risk here. The way that we're seeing agent developers do this is they're creating 2 systems, like a very tightly controlled system where the states that are possible are very tightly monitored by the systems themselves. So they use agent ops, for example, to monitor when an agent is doing something that it shouldn't be doing. But second is introducing humans in the loop. So for example, if you buy a very expensive item and you want to get a refund on that, the AI agent will help guide you through that process. But at the end of the loop, you're actually going to have a human click the button and say, yes, I approve of this. So humans are actually, I would not say that agents are going to replace humans anytime soon. Far from it. In fact, we're becoming a little more like centaurs. So centaurs are like, you can have like half man, half horse in Greek mythology. You got to think of it as the horse or more like a cyborg, right? You know, we're going to be empowered by these machines to help us make decisions faster rather than all humans doing all the grunt work.
Rep Savian, follow up. Committee members, any other questions? I think I've got a couple, but want to make sure everyone gets a bite at the apple. Ms. Co-Chairman, please go ahead.
Thank you. So, Mr. Reedman, you know, one thing which is amazing about this is everything you just showed. We're still in the early days of this endeavor in terms of high functioning LLMs and then building additional capacity on top of that. What do you see ahead of us in the next couple of years? First of all, in a broad sense, but in a secondary sense, as legislators that we might want to be really trying to get ahead of potentially. This is something we talk with Daza a lot about, but do you have anything in mind where we want to start thinking about something because of the direction this is going to be going in the next few years?
Mr. Reedman, go ahead.
Yes, absolutely. So I have opinions on a technological standpoint, but actually I think my biggest concern is from an educational standpoint. So one of my favorite college professors recently moved to a new department and is teaching a course to business students on how to use ChatGPT. And what was shocking to me, or at least to him, was very few students actually knew how to use these tools in general. And the ones who were becoming A+ students, not just in his class, but every other class they were taking, because it really just confers on a massive educational advantage. I also have an aunt who is a school teacher who has noticed something very similar, which is students are able to learn a lot faster by utilizing these tools and just knowing what's out there. So I think it's part of it is just, knowing how to teach people to use these things in general is what makes them most productive. Secondarily, so I think that, does tie into what you might want to consider from just, how from a regulator's perspective. But I'd say, from more kind of like a technology and an interesting technology perspective is there's been a lot of regulation in California, for example, trying to put the hamper on large language model producers, saying that they need to be under tighter scrutiny, they need to be a lot of legal fees and so on and so forth just to train models. What we're actually seeing now is model training is moving from a lot of the big players to becoming more democratized. So instead of seeing a world where only OpenAI is the one who's able to afford to train ChatGPT, you might be able to see somebody train ChatGPT in their garage within maybe 5 years or sooner. So there's been a lot of push towards over-regulating and basically giving a lot of advantage, conferring advantage to incumbents who have a lot of money, a lot of lawyers, rather than you have a lot of homebrew projects. So a very cool homebrew project we've seen is called News Research. They're building off of Facebook's Llama models, the basic fine-tuning them. They're fine-tuning on top of Mistral, which is another open source provider. So basically giving the ability to, or just enabling people to build out their own models and break free from a lot of big tech, which is really trying to dominate the space right now, is a huge way that we've been thinking about it. And in fact, with Agent Ops, we see a lot of users who are very concerned about privacy, especially when they're working with private data like healthcare data, and they don't want to be sending their data to OpenAI. So making sure that people are able to get democratic access to this technology is a big thing that we've been thinking about.
Mr. Co-Chairman, please go ahead.
Thank you. And you mentioned guardrails and you mentioned overregulation. It seems like those two things go a little bit hand in hand, because we're seeing the regulation leading to guardrails that in some ways decrease the efficacy of the large language models and lead to information that isn't necessarily the best information, but it's the most well sanitized information perhaps for the answer. Do you see any methodology through agentic AI of maybe finding some type of middle ground where you could have a language models that are trained, we'll say, a little bit more purely, but then perhaps having a second agent as an appropriate filter that one of the larger companies might want to employ, but maybe other individuals wouldn't want to employ? Is this something that might offer us a workaround from the challenges that I think many have right now of getting clear, direct information or best answer out of an LLM?
Mr. Riemann, please go ahead.
Yes, that's an excellent question. In fact, this is kind of the line of thinking that a lot of the AI researchers are actually employing in their day-to-day workflow, which is instead of creating kind of like a Socrates agent that's really good at everything, but you kind of have to tamper it to make sure that it behaves in a certain way. What if you have kind of like a bunch of small agents that work together to create decision-making processes? And that's what we're actually seeing with a lot of these frameworks, which you have multiple agents work together that are basically specialists. So one specialist agent might just be for censorship, right? So making sure that toxic content doesn't reach the users, or malicious content or malicious code isn't produced by a code writer agent. Whereas the code writer agent might just be kind of pure in intention in terms of it's fine-tuned, it's specified and trained specifically on a certain task. So data extraction is a very big one. We see a lot of companies that are extracting data from PDFs. We don't really care that this agent knows how to recite the Gettysburg Address. All we care about is that it knows how to extract data from PDFs. But you might have a secondary agent that's just like a proofreader, and that's specialized in proofreading these things. So it's a very excellent thing. I'd say that kind of as a conclusion point, though, is that it's very subject to experimentation right now. And we're seeing a lot of, it's all driven by evaluations and benchmarks. So knowing exactly how these models are going to perform in the real world is impossible until we, obviously deploy them in the real world. So what we do is create like very, very robust hundreds, if not thousands of tests where we can run these agents against them and see how can we expect them to perform in the real world. If we throw the hardest, thorniest problems at them, if we try to jailbreak them, make them do bad things, are they going to behave as expected? And then it's a continuous monitoring process. We try to play a very tight role in that, making sure people are deploying models that are continuously monitored. But it is an ongoing security question, and it's how you deploy these systems at scale. You have to constantly make sure that they're updating, and you're constantly trying to break them so that they can improve themselves.
Great. Thank you, Mr. Chairman.
Thank you, Mr. Co-Chairman. Any further questions? I know we've got some other folks teed up, but I want to maybe to get a question or two in. Mr. Riemann, kind of piggybacking a little bit on what my co-chair talked about in terms of just bias, inherent bias in these algorithms and these LLMs, and is AI, does AI offer a solution to controlling for that bias, or is it actually an accelerant of that bias, whatever it is? I know we want to think about it in the hot terms of what bias means, but in the very broad context, is it really going to help us with that issue to control it, or is it actually going to be an accelerant and make it worse?
Thanks for the question. I think it's a really hard problem to address specifically for a couple of reasons. Number one is with machine learning, broadly speaking, and this is prior to large language models, we're even thinking about neural networks as they've evolved in the past several decades. It's very hard to understand how these things work. In fact, many argue that it's an intractable problem just because of the amount of linear algebra and statistics that is under the hood of these things. We don't think in floats and integers as humans, we think in ideas and concepts and reasoning. So indeed, it's hard to understand what the biases are when they do appear, but when they appear, you know them, right? You can ask ChatGPT what its opinion about something, and usually it declines to answer, but sometimes it gives a very either I would say globally speaking, neoliberal response, right? Oh, I think people should be free rather than living under a tyranny, right? Which is a bias in a way, right? Bias towards values that I personally hold and Americans hold. But it all does kind of stem from this fact that these models are trained on text that we as humans write. So the entire corpus of human civilization, every piece of literature that's been written, every line of code that's been written, every article on Wikipedia, that's what it's learning from. And I think it's like that collective knowledge is actually the bias. So whatever you think that the collective opinion of every human that's ever written is, actually that's what the biases are. And we are seeing a lot of efforts towards kind of like fine-tuning these models on specific documents so that, again, for business use cases, they don't want to be political. They just want to extract data from a healthcare card, right? Or maybe you want something that's more factual and answering research questions, and you don't want it to be biased by political leanings. That's quite challenging, and that's where we introduce a lot of extra fine training and extra fine tuning to make sure that these models are kind of aligning with our incentives. And the incentives at the end of the day are benchmark driven. So I think that for bias specifically, we've seen a couple of benchmarks come out saying, oh, there seems to be liberal biases with a lot of large language model providers, but it's actually improving over time because we've become more aware of the benchmarks and we're trying to address those as they're coming out.
Thank you, Mr. Lieb. The bias is the opinion of everyone who's ever lived. I like that. Maybe one more quick one before we move on to Campbell. Obviously your expertise is much more, or certainly appears to be in the technical realm versus the legal, but you train your LLMs regardless of whatever the angle is on, all the data it can possibly get its hands on, right? And this is something that we've talked about extensively with DAZA is the provenance of that data, and is it okay for you to train your LLM on my data, right? Maybe me personally, Cyrus Western, or just kind of in a broad sense of allowing that. I mean, are you aware of any conflicts that are currently unfolding, or is that something that you're worried about is data provenance and the quality of the data you can feed into your LLMs? And do you sense a fight over data provenance and LLM training?
Mm-hmm. So personally speaking, we don't encounter that very much ourselves, but our users do. So for two reasons. Number one is a lot of companies have proprietary data sets. And when you're sending a question over to ChatGPT, which is managed by OpenAI, unless you're on their enterprise plan, there's a good risk that they're going to be training on your data. It's at least it's very hard to say that they're training on your data. And people don't want that, especially when it comes to private records, customer banking data, customer healthcare data. We don't want that data to be in the hands of a model, right? I don't want my health data to be part of the global record, so to speak. And that's actually where kind of a lot of the data users that we've seen are relying on open source models. So Meta, for example, created an open source model. It's very hefty, but you could probably download it on your laptop. In fact, on the smaller models, you can download them on your cell phone. It heats up your cell phone. It's not the best, but it does work actually surprisingly well. And so I think that a lot of this is what you're kind of referring to is more on the training sides of things. And the question that a lot of our users are saying is I know my data is going to be sent to a provider who I have no control over. How can I make sure that data is not going to be trained on in the future? So as far as the initial data sets go, I think that a lot of the LLM providers have data licensing agreements or have taken unlicensed open source licensed data such as a Wikipedia, which allows you to kind of scrape this stuff. But there is an open question about if I have current data, how do I make sure the models aren't training on that? And that's where people are relying more on enterprise plans with LLM providers or using open source models.
Excellent. Well, Alex, I feel like we just on you alone, we could probably go back and forth for hours and hours because this is, again, it's very stimulating stuff. One last chance. Any questions for Mr. Eden before we move on to the next person? Seeing none. Again, Mr. Eden, we really appreciate you setting aside some time. This is super helpful stuff. Daza, next up, I've got Campbell Hutchison. Is that correct, Daza, or who do we want to tee up next?
Yes, Mr. Chairman, if it pleases the committee, I think Campbell will be the perfect demo at this point in the testimony.
Okay. So Campbell, or Mr. Hutchinson, the way it works when you're testifying for these committees is just state your name, who you're with, and maybe tell us a little bit about yourself. And we're excited to hear what you have to say.
Okay, awesome. Can you hear me?
Yes, we can.
Okay, awesome. So my name is Campbell Hutchison. I was previously, a little bit about myself, I was previously Chief Compliance Officer of Datto, which was a public unicorn in Norwalk, Connecticut. And I worked there for a number of years on issues like data privacy and other kinds of export controls, different kinds of technology regulation. And then recently I was Chief Product Officer of Norm AI, which was a company building agents in the regulatory vertical to help automate regulatory compliance. And that company recently did a large Series A. And I quit that company in order to sort of do research and explore more ideas around how the law and agents interact. What you're going to see is I'm here with Nam and Alex, who are the co-founders of Truth Systems. And you're going to see a sort of a demo we put together to explore ideas around how it is that lawyers can use AI agents in order to help comply with their professional conduct obligations, especially those created by AI systems. And so this was a project we did with Stanford Codex, and it was greatly inspired by Daza's work with the California Bar. And basically, you're going to see sort of two parts. The first part is a section around like how it works technically, and the second part is the demo. And we're going to split that up. So Alex is going to talk about how it works technically. Nam will talk about the demo. And if you have any other questions or whatever, I can answer them at the end or at any time.
Excellent. Please proceed.
Okay, cool. Alex, do you want to introduce yourself and jump in?
Sure. So my name is Alex Mack. I'm part of, I'm one of the co-founders of Truth Systems. We work with Campbell and Stanford Codex pretty heavily on projects regarding trust and safety when it comes to interactions between generative AI and agents with law. Just a quick overview of what today's demo is going to be about. It's one of the ideas we've been exploring about how we can make lawyers and interactions with lawyers with law more safe and compliant. Essentially, we notice that a lot of lawyers are unaware about the limitations of this technology. And frankly, it's not in the job description of lawyers to understand how AI as a whole is compliant or uncompliant with certain ethical guidelines. And so our goal was to create an agent that helps lawyers interact with other generative AI systems in a way that preserves confidentiality, in a way that utilizes models and these agent systems to the best of their capabilities. And essentially what you'll see is two features that we'll show you today, just for the sake of time. We'll show you one, which is about how we can actually construct better prompts. This being, how can we make the instructions that lawyers give to generative systems better, more predictable, more high quality. But at the same time, how can we make those compliant with confidentiality guidelines that these lawyers have to abide by? So you'll see a quick demo here. And let's say I have a very, I'll zoom in a little bit. Let's say I have a very quick prompt about asking for incorporation of a business in the United States. This is a very vague general prompt. If I submit that, you'll see that our model identifies that, oh, United States, maybe we should be a little bit more specific. You know, incorporating in Delaware versus California has very vastly different implications. And then let's say we get the legal analysis behind this prompt. You'll see very quickly that we'll have a answer regarding what this prompt means in the business structure, in the how do the names, the article of incorporation. So this is essentially when you'll pass it on to, this is essentially how you'll pass it on to whatever generative system you use in the end. Let's say we have, let's say we start over. Let's say we have a little bit more of a question regarding a bank. Who is a bank? Let's say it's a large bank based in New York with revenue of approximately 50 billion yearly. They are looking to restructure. Fees. How should I approach? So this might be a type of prompt that a lawyer asks a generative systems just so that they have kind of bouncing ideas, getting a little bit more details regarding how they want to approach this, just listing as many options as they can. So let's say we have a national bank headquartered in the state of New York. We're not super sure, and then we ask it to say, optimize their legal expenses. If we run the scan, we'll see that it fails the scan because we have suspect of clients, of two specific clients, example ones that we've loaded in the system. And we suspect that this prompt is talking about JP Morgan and Goldman. In this case, a lawyer might say, oh, we know that these clients are not very happy with us using generative systems, or we know that they are very hesitant about confidentiality and PII issues, and we must be slightly more careful before we send this prompt over to any generative system. And so in this case, if the lawyer sees that it fails a PII scan, they might refer back to the client preferences regarding whether they allow them to use generative systems, regarding whether they allow them to have kind of riskier prompts, which might be identifiable based on the information put here. And the information we put here right now in the example is very generic, but you can imagine lawyers might go into in-depth detail regarding information of a client that is not public, that might violate confidentiality. And so the next, I think Nam, you can talk a little bit about it.
So Alex, real quick, my apologies for interrupting. Just want to make sure.
Mm-hmm.
So the model can detect that there's a potential conflict of interest and it might be giving up its element of anonymity. Am I accurate in understanding that at
Yes.
its cognitive level in that matter? Wow, that's pretty impressive. Please continue.
Yeah, so hello everybody. I'm Nam Nguyen. I'm also a co-founder of Truth Systems. And yeah, I'd just love to talk a little bit about the context that putting into the context of the hard work that Daza has put in for the ABA for ethical framework in Gen AI usage, one that prioritizes like responsible use of AI to uphold client confidentiality, as well as a lot of the conversation before that Alex was talking about, where implementing guardrails. We strive to define the role of agentic AI to be felt in the legal and compliance space as follow. One that can do automated compliance, mitigate risk in real time, and create traceable logs that is better for accountability. So whether that is streamlining compliance processes by automatically monitoring and interpreting regulatory changes, it can also like mitigate and detect this risk, as you see from Alex's demo earlier, where it might look at a potential client that is being mentioned that has not allowed for disclosure of information. And finally, these can create logs of interactions that can help us set up regulatory framework, as well as creating processes to track decisions, actions, and making it really easy to assign responsibilities and fix problems when needed. So I think on top of what Alex has spoken about, agents being able to really drive productivity and do really complicated tasks, we can also use agents as a way to uphold better risk management and strengthen accountability, all while operating within an ethical frameworks that safeguard against potential pitfalls when we're building these autonomous systems. So that's it. Thank you guys so much, and I'll yield it back to Campbell for any questions.
Campbell, please proceed.
Oh, nothing. We were just sort of letting, if you guys had any questions, we were just sort of opening up.
Committee members, any questions for Campbell or Mr. Co-Chairman, please.
Thank you. So from our perspective then, as lawmakers, do you see any best practices that we should be really looking for at this point to potentially implement through statute? Or is this something where we want to wait a little bit and see the direction things are going? It's clear that what you're advocating for is a good set of best practices that ends up protecting privacy, ends up protecting against conflict, and basically everything else. So you're carrying out the best practices while using the model. But do you see anything that requires actual regulation to implement, or is this going to be something where the market's going to take care of it?
I think
Mr.
that it's a
Hutchinson, go
good.
ahead, please.
Oh, thank you. I think that it's a good idea to take a look at sort of the work that the California Bar has done around best practices for using AI for lawyers. And I think that that's a good place where some pre-work has been done on trying to figure out what steps lawyers should take before they use generative AI to make sure they're using it in the best interest of their clients. I don't think any regulation needs to be done today, though, because I think what's sort of happening is there's going to be sort of a great experimentation, and you're going to see a lot of products come into existence that help lawyers sort of like manage their legal work and manage their legal obligations and whatnot. And it's probably something that you want to wait a year and a half before you directly regulate, or maybe 2 years, but you want to sort of keep apprised of what's going on in the market and keep apprised of what's going on in other states, because I think you're going to see a lot of experimentation.
Mr. Co-Chairman.
So the other day I had a conversation with one of the faculty here at the University of Wyoming about the idea of training an LLM as effectively an oracle for the state of Wyoming, for the public of Wyoming to ask legal questions, we'll say, and then obviously you'd want to be putting some disclaimers and making sure that it wasn't legal advice, but giving it access to all of the statutes, but also all of the rules and regulations of the state, all of the ordinances of the cities, towns, and counties, and even potentially engage with case law. So the case law is there. So you have this oracle that would really know the legal scene of the state of Wyoming better than any individual. It seems incredibly plausible, but what guidance would you have? Well, first of all, I'll say, do you know of any projects along those lines elsewhere? Is anybody else working on anything like that? It sounds like this is right up your alley. And second of all, what would you immediately be thinking about that would need to go into something like that from the protecting the consumer and recognizing the limitations of such a model?
Mr. Hutchinson, please go ahead.
Sure. So the city of New York, I believe, is doing something fairly similar to this. I don't know if it's over like all of their regulation or just over a subset of their regulation. What I would say is that at this point, the difficulty is that the answers that you're going to get out are going to be suboptimal without a lot of tuning. I think this is something that every state is going to have to implement. And I think it's incredibly important because I think that like one of the powers that LLMs offer us is the ability for people to understand what services the government has, what regulation affects them, and to be able to do that without the benefit of without having to turn to a lawyer and pay $500 an hour for every little thing. So I think that this is really important and needs to be done, but I think that managing the quality around it is difficult, and something that you can do to sort of help manage that is to pick a particular like area first to focus on, and then it's easier to make sure that you get the quality right. And so that's what I would say. I would say start small and then expand. The model capabilities are going to get way better. You're just going to have tremendous uplift there. So in like 2 to 3 years, this will be way easier than it is today. But I think it's completely the right direction.
Well, Mr. Co-Chairman.
I'd say excellent. I didn't know if either of the two colleagues had anything to add, but that's an appreciated answer. I think certainly starting off and building this piece by piece would certainly be the way to do it. Appreciate that. So,
Mr. Hutchinson, and maybe I don't know if this is also for Alex or for Nam, but the demo you guys gave was, you're trying to structure or figure out your fee structure, and your client is obviously a large New York bank. Do you think that this LLM now has the capability to give policy prescriptions for lawmakers like us? Because I think one of the things we're always certainly when we're crafting legislation is what are we solving for, right? What is the problem? What are our options to solve it? So do you think that this model has that capability where it's assuming obviously you're giving really high quality prompts of the policy of the problems you're trying to solve, can it give pretty detailed and intelligent policy prescriptions? And if not, how far away are we from that capability, would you say?
Alex and Nam, do you guys want to take this
Yeah,
one?
I think we experimented with something pretty similar before, and the conclusion we came up with was that it's about the level of an undergraduate in college, right? It can compile a lot of grunt work for you. It can compile a lot of research for you, but to make the policy prescriptions themselves, it's a little far away from that still. I think the best usage for a lawmaker like yourself, the best usage would be using it to speed up the context gathering, to speed up all the background information you need behind the policy, and to speed up the research process behind getting all this information condensed together. But it still struggles at effectively applying reasoning and logic and understanding the context when applying those prescriptions to make policies that are actually effective. So I do think that there is a huge, tremendous value in the context and research process, but I think we're still pretty far away from actually generating the policies themselves.
Yeah, I'd like to echo some of those.
Yeah, please, Mr. Reedman, if you want to hop in and chime in, we'd love to hear it.
Yeah, I absolutely agree with everything that was just said. I think that the general way of thinking about these models in general are you have two main levers. So you have the model itself. So the model itself is created by somebody training on hundreds of GPUs with millions, trillions of tokens of text, and it's able to create internal reasoning based on top of that. So for example, ChatGPT, OpenAI just launched a new model last week called the O1. And what it's capable of doing is actually create steps of reasoning to think about how to solve problems. So that's one aspect of it, which is the underlying model powerful enough to solve this problem? The second is the information gathering. So when you train a model, it's saved at a point in time. So O1, I think, was finished training sometime a few months ago. So it only has model knowledge up until that point. It doesn't know the current state of things, at which point it's going to need to gather external context to understand how the world works. And obviously, there's going to be data that the model never had, which was private for whatever reason that it was not trained on. So those two aspects that are what makes it a model essentially powerful. And in terms of replacing a policy or a regulator, it's really hard to say. I'm not sure that we want to strip ourselves of that agency just yet, mostly because, well, not to be too facetious here, but we as humans, right, we don't pass the best legislation ourselves. So why do we think an AI is going to do a better job than what we can do? Essentially, when it's trained to follow our examples. So if it's following bad examples, I think the AI will probably do no better. So it's really up for us to improve. We can use the tools to gather better context and make our lives easier, but I would not use it as a replacement.
Mr. Cohen, what co-chairman, what I took away from that is that we still have jobs.
Still have jobs. That's right. Keep us for a little while longer. I think Nam wanted to say something too. It looked like he.
Yeah, please. Now, if you wanted to chime in, go ahead.
Oh, no, I think that's mainly the thing. And honestly, it's what we've advocated ourselves as well, is that, yes, it's the model's very much far away from like taking people's job. And it's even more important that we place processes and best practices, whether that is like a framework or guardrails. That is going to be the most important thing when it comes to implementations and usage of AI. I don't think people's jobs are going away soon. I don't think high-level thinking is going away soon. It's really about how we use these tools and how we design the ecosystem for these tools responsibly that can best leverage its capabilities. I think that's the most important thing.
So, and this is kind of a broad question, whether it's for Mr. Reedman or Mr. Hutchinson or whoever. If I heard that correctly, you said we're at about an undergraduate level in terms of cognition to think about these things in the big picture, right? I mean, and you said, well, it's kind of limited by the fact that they're a reflection of the humans who program these LLMs and AI, so they're never going to be able to perform at a cognitive level at the same level. But is it reasonable to assume that eventually we will get to a point where, as long as you have the quality prompts into these models, that you'll be able to get pretty sophisticated responses back when you're trying to make policy prescriptions and solve issues? Is that a reasonable assumption?
I think it is. And I think that not only is it a reasonable assumption, but the models are just going to get more and more powerful. GPT-4 was a step up on GPT 3.5. GPT-4o1 is a step up on GPT-4. Like, the model capabilities are just going to get better and better. And so if right now it's an undergraduate level, then in 2 to 3 years, it might be a graduate level. Like, I think that it's dangerous to underestimate the increasing capabilities. And basically, whatever you have now, it's just going to get better, and it will certainly be able to help you make policy prescriptions as it gets better. You'll always have to check the edge cases, but the models will get better.
Yeah, I'd like to echo that point, which
Maybe-
actually I would argue that perhaps,
Go ahead.
oh, I'm sorry, there's a bit of delay. I would say that it's actually able to answer a number of perhaps graduate level question exams. So there was a famous economist who ran some of his intro to graduate economics course exam questions on that, and he said it's an A-. It's quite good at answering these sorts of questions. It's good at managing trade-offs. It's good at understanding policy prescriptions. But ultimately, the way that we want to think about this is these are our tools. So it's able to do the research for us, but it's up for us to check the homework. And it's going to be doing so at a more effective rate. But I doubt it's going to go out of control. And I'd actually probably invite you just, try it out yourselves. ChatGPT is the price of lunch. It's $20 a month. And you can really kind of, upload a proposal and see for yourself how effective it is. And it might be very helpful for guiding instructions, but I would not forfeit control. That's kind of my prescription.
Mr. Riebman, no doubt, but I'm going to go ahead and hazard to guess your prompts into GPT will probably be better than mine. My question is, I'm sorry, Ms. Co-Chair, I said I have one follow-up because I'm trying to think through this. In the legislature, we have a saying you can't legislate morality, right? Because it's such a highly subjective topic. Do you think that, or to what extent will your model or any of these models be able to grasp the concept of subjectivity and giving ideas and answers and policy prescriptions? How comprehensive is it now? And do you think it'll ever get to the point where we can, grasp the concept of subjectivity as humans?
Mr. Chairman, do you mind if I pop in at this point?
Sure. Yeah, Daz, please go ahead.
Thanks. I just want to add another layer to the excellent testimony of my peers, which I agree with. And I think your question is a really good segue to this additional layer, which is that this technology, and by that I mean the foundation in what's known as the frontier models. So like the most powerful models, GPT 4o1 that was just mentioned, Sonnet 3.5 from Anthropic, Google's Gemini 1.5 Pro, the experimental ones, and so forth. They actually are unusually good at some of the softer reasoning and what would be thought processes, more so than they are at things that we always thought computers are good at, such as calculations. It's because the nature of the model is different. It literally, the process that they do is called inference, and that there's a good reason for that, as it sees these patterns, deep in the sort of semantics and the conceptual layer of all of the corpus of its training data and all of the ways that it was pre-processed. I have found, and there is research that shows, it can be quite good at identifying moral aspects, ethical aspects, sort of potential liability, things that could come back later and cause issues, partly because these things have happened again and again and again over the wheel of time, and it's reflected and supported in the training set and in the connections that it makes in high dimensional vector space. So it actually has some surprising and deep capabilities that can be very useful along these lines. And my take on it is, while I agree with my colleagues, not to abrogate your duties or your job anytime soon, or probably ever, for real reasons of just my sense of the role of humans. I actually think I would suggest somewhat a different vantage point, which is that if I were back in a legislature, as I was in my younger days, I would not miss the chance to leverage this technology for every single phase of the lawmaking process, from coming up with helping to come up with questions for the witnesses, helping to look at potential different options for legislative treatment, analyzing deeply, the different provisions of given bills, their interaction with each other and with other laws. Political questions, it's quite good at. I'm working on a couple campaigns now, and it's really, really good. As has been mentioned, so much, almost everything is dependent on exactly how you phrase the prompt. The more expert you are and the more knowledgeable and competent you are in your system, the better you can frame that prompt. And the other most important thing is to feed it additional data, like the rest of your docket, what your priorities are for the select committee this year, what else is going to hit, all the same stuff that you would tell somebody else that you're asking to help you on any of these matters, you would feed into the context window, it's called, as additional data. But with those provisos, I think these are very, very capable now. And what makes it, and the reason for putting this panel together today is all of the answers that have been given so far in the legislative context impliedly assume a person and a model through a chat window, maybe enriching it with some more data, which is fine, and you should do that. But what we're talking about today is agentic systems. And as Alex showed, these agentic systems, and as I'll show in a moment in my remarks, when you start sort of stacking teams of these agents that can look at the same question from different perspectives, and then maybe have additional instructions and have additional data, and that can collaborate with each other, I think that's the power move that elevates its capabilities well above what an undergraduate can do and puts it into a domain expert level of quality and competence. And so I just want to sort of mention a little different, somewhat of a different kind of center of gravity in my remarks is it's not 2 or 3 years, I don't think, for these to be very capable and usable for your purpose and so many others in the society and the economy. I think it's today, and the trick is using them well and unleashing the height of their capability with agentic systems.
Thank you, Daza. Mr. Co-Chairman.
Thank you, Mr. Chairman. And Daza, I've been using all the various builds for a few years now and trying to use them more and more for legislating and asking. We've talked through some of these questions, Daza, on trying to ask very complicated questions, see what type of response and what utility there is, and as well as having, GPT 4.0 draft legislation. I haven't done 401 yet to draft legislation, and it might do better, because one of the problems it's had typically in the past, which an agentic system will take care of, is it's almost like it gets exhausted. It only wants to give you so much. So if you ask a very specific, narrow question, you'll get a great answer and you'll get a perfect paragraph, and that could go into a bill draft. But if you say, all right, I want to draft a bill on this that does these 5 things, it ends up being very superficial. So we're getting to the phase now, based on the testimony today, that rather than it being superficial because you've asked it a more complex problem and it gives you more of an outline, it sounds like now we're getting to the point where rather than doing that, it will first ask itself the question, develop the outline, and then start to fill in the outline with robust content. So even with 01, where it's trying to logic out pathways, perhaps it can already do a better job. And as I said, I haven't tried drafting a full bill with 01 to see what it comes up with, but that might be a good next step, Mr. Chairman, is to kind of see where that's at. As far as kind of where it goes from here, though, when we think about these complex tasks, one of the things that I've noticed is it's incredibly skilled at operating inside a sandbox and you said inference, it makes good sense, right? It tends to interpolate seemingly and come up with interpolated solutions. But whenever I've asked for something which would require some type of intuitive leap outside of the sandbox where it's making up new knowledge, it doesn't do that very well. Is that something that we can expect to change and evolve? Is that something that is being worked on where those intuitive leaps will strengthen over the next few years? Or is that a necessary challenge of the underlying structure of the technology where it really is inference based and interpolating more than extrapolating? And I don't know who wants to answer that. So I think just about anybody
I think any of us could,
there
but
can answer that.
Yeah, that's
Mr.
open answer, Dazza, or?
Yes,
Kim?
thank you, Mr. Chairman. Actually, and I actually go into this directly in some remarks that I put together. I wanted to make sure my colleagues could go first, just in case we ran out of time. But is there time for me to go through a few slides? And the punchline of the slide is we're not waiting 2 or 3 years for that. I can show you how it's happening today.
Awesome.
Dazza, please proceed.
Thank you so much. And I will go through the ritual of saying, can you see my slides?
You are good to go.
Great. Agentic AI obviously has some, I'm more like the person on the right. I see a lot of promise. There are perils as well, and we've gone through some of them today. Just by way of background, I first started getting into agentic AI in 1997 when the drafting had begun in some states for what became the Electronic Transactions Act. This is a memo here from the ABA committee, which I was on, that was helping with that draft on the electronic agents provisions. And only now are we finally at the point where we can where we're finally starting to get to the point where these agentic systems can operate autonomously. In 2011, I worked with the law firm known as Robot and Wang to create a prototype of a corporation in Delaware that was completely autonomous. At MIT, we tried to create an automated credit union, federally chartered credit union. We got a certain distance there. We've done things with automated legal entities over the years. Always the technology wasn't good enough for some of these things yet. I think it is today. And personally, I've taken a step back from a full legal entity and just been working on individual projects and seeing how far they can go through the life cycle of a project. I don't believe Alex Riebman showed this, but he shared with me a slide deck that has 450 startups and products and services and open source projects that are good examples of agents. We can share this link with you as well. This is just to show that while it's still relatively new in the sort of general zeitgeist, agentic systems are here now that are leveraging and extending the capabilities of generative AI, and people are beginning to use them for transactions and for matters that have legal import. And there already have been some issues. You may have heard over the Christmas break about the chat system that was that a car dealer had put online to help people with their getting in understanding what the cars were and starting to look at what the pricing would be. And somebody was able to jailbreak that and convince it to sell a new Chevy Tahoe for $1. This could be a problem. Air Canada had a chat bot that materially misrepresented its refund policy. The consumer took them to court, and the judge made it crystal clear that when you use these agentic systems in this case customer service context, that you the companies doing that are responsible for the outputs of those systems. So I think it's timely, and there's two big tectonic things happening beyond the power of the underlying models. And it's what's known as the context window and these agentic workflows. The context window is how much data you can put in to the system what in a given session. That's profound, but we'll focus today just on the agent part, although these things are connected. OpenAI has been working on agentic systems for some time. I think we'll see a lot more explicit output from them through the rest of this year and early 2025. In their paper that they put out at the end of last year, when they were sort of clearing their throat to get involved in this, they defined this next one. They defined agentic systems as unlike, say, using it in a chat context or a different context. They can deal with complexity of your goal as well as the external environment. They can adapt to that, and they can independently execute an action to meet that goal with limited, or in some cases with no human review or approval. Two of the big areas of application are doing project work, as part of your job or life management, and also transactions. With projects, people haven't mentioned this very explicitly, but let me just say, I think the heavyweight champion for agentic systems right now is software engineering. A lot of software can now be engineered almost completely, or in narrow cases completely, through agent-based systems. Devin was the first widely recognized software engineering system to allow a user to put a goal in, and then it would create, I don't know if you can see the screen on the right, but it sort of spawns a crew of agents that do different aspects of the software project. And it may ask for some guidance a little bit from time to time from the user, but it turns out working software at the end. Now there's a renaissance of this type of software happening now. Replit is a big platform to help with software engineering. It will create the entire front end of systems in minutes and deploy it onto the web for you based on a few prompts. Cursor may have been mentioned. That's another one. There's quite a few. Campbell mentioned applications in the legal and regulatory space when he said he had been product lead at Norm.ai. Norm.ai is applying the same kind of method, but not to software engineering, but rather to regulatory compliance. And they have just finished a very successful Series A and are working in a number of regulated industries. Spellbook, we almost was able to do a demo today. I'll just say a few words about what they launched a few days ago. They call it Associate. This is for law firms. And this agentic system does the work of roughly a junior or early mid-level associate at a medium or large law firm. It will create a plan based on the user prompt. It has access to the law firm's knowledge bank and relevant client information. It will go through and create agents to do each part of the plan. So getting back to Senator Rothfuss's observation a moment ago about his early work trying to do bills and how it kind of gets tired after the first few paragraphs and starts to drift a little bit. This happens partly because of the context window and the session limitations. But when each agent you spawn is looking at one part of the problem and it's being orchestrated by another agent, you always get the highest quality, best work on the little part that they do. That's partly how Spellbook works. And then it puts it all back together. They also have a cool design pattern that I use in my systems, which is after they put it together, they look back at the plan and say, not only did this do the plan right, but did we have the right plan to start with to meet the goal for the client? And they may change the plan a little bit if their internal evaluation says it wasn't good enough, and then go through and run the whole process again with an improved plan. Really interesting stuff. So these hybrid teams of agents is something I want the committee to be aware of. Agentic systems, when you start having each individual agent within a context loaded up with context and basically expertise and instructions through the prompts to look at things from a certain angle and to focus on a certain aspect of it, you can make a huge progress that wouldn't be available with one agent alone, and certainly not with one person prompting through their limited context capability, limited context window. So if you have a legal agent and a technical agent working together, for example, on software, the software could end up being more compliant. One of the agents could create the terms and conditions for your app, could look at, other legal arrangements or partnerships you have, can really deepen the output of the agents. Similarly, a lot of the work now is happening with so-called business-oriented agents, financial, marketing, et cetera, et cetera. You put those together with legal agents, very deep. Business, legal, and technical agents operating in teams, incredibly powerful to go from a little prompt to a really good deliverable at the end that your team can work with and start getting to something that you can deploy very, very quickly and may in fact be better than what you might have come up with on your own. The demo that I showed you, Chairman Rothfuss and Chairman Western, a little earlier, that I call Agento, is just such a system that uses business, legal, and technical agents to come up with a plan, break it down into smaller parts, work on the different domains of the plan, and then kind of put it all back together into a single deliverable. I think there's a lot of promise in this approach. And now to Chairman Rothfuss's most immediate question, which is, what about novel ideas? Can it go beyond what we already have and just be completely derivative? I think the answer is yes. I think we can say that now for sure. And let me just look at a different domain, which is science. Scientists and scientific researchers have been using this technology as part of their own work. Back in 2023, it was shown that these models can create, equal or better introductions to papers than humans, and they kind of double-blind tested that. And in the months ever since, there's been a lot of studies that have shown that these systems can do whole parts of the scientific process very, very well when you tune them just right to do so. And that one on the bottom from September 6th of this year, can LLMs generate novel research ideas? The answer is yes. I mean, they have a question mark there, but the answer is yes, it can generate novel research ideas. And this is the one I would most encourage you to look at. It's called AI Scientist. It dropped a few weeks ago. It's completely open source. And this research lab in Japan basically put the entire life cycle of a typical scientific research project together, from ideation, that's generating new ideas, checking them, going to different papers to see if it's novel or not. Then it pushes it to the next kind of phase there, which is it can devise an experiment, sort of like a software engineer, synthesize data if needed, or go and fetch the correct data to run the experiment, get the results of the experiment, do some kind of data plots and graphs, see what's novel, and then go right to manuscript writing from the results of what it discovered, publish the manuscript. And so this is pretty incredible. I will be the first to admit, having implemented this, a lot of the ideas it comes up with aren't that great. What's fascinating is some of the ideas it comes up with every run are novel ideas, and it can then go through the entire life cycle. Now, just imagine for the moment, not long in the future, when this life cycle is for legislation to assist in the legislative process, or when it's for new product ideation and right down through deployment, and every other part of the economy and society. I believe we're there now. And one critical part of that is when these things are empowered to actually conduct a transaction at the end, like to deploy the app or to purchase the good or sell the service or what have you. This is much dicier. However, there are systems now that are already purchase agents are quite common, shopping bots, to go and find the best price on a given product or service, and then to give them some money, like a debit, a value card, or even a credit card with limits, and for consumers and for procurement, this can be very, very efficient. The best practice is obviously at this point, don't let it conduct the transaction. I'll put that right out there, like have the human click the final button, but people are giving it this kind of agency or this type of authorization, and it's working pretty well. And we're also now able to identify flaws and problems and unexpected outcomes that give us the ability to focus more on how to fix the code. And the code isn't just technical, it's also legal. So this new research at Stanford Law School and Codex is something I've been leading, where we're looking at legal frameworks like eSign, UITA, other parts of contract law, and seeing whether we can design better transactional agentic systems that avail themselves of the electronic signature, automated transactions, the error and mistake provisions that benefit people with security procedures and so forth. Also, the electronic agent provisions to support and reflect these rules to get more predictable legal outcomes when people use this technology to conduct transactions, which they're doing. The most recent way people talk about agentic AI for transactions is they call it a large action model, or words to that effect. That's been that was sort of, there was an initial hype around that about it 9 months ago, and that sort of settled down a little bit when people saw that the technology was still a little bit buggy, but it's coming up again now in a more modest, more narrowly focused way. And these are some of the types of, I guess I'd say, actions and interactions and some transactions that agents are commonly put to. If you go through that 450 company and product list that Alex put together on the spreadsheet that I showed earlier, we could add a column to sort of say which ones of these interactions or transactions are each one of those doing. And so just in closing, I'll say that the Codex research, we probably need another couple of weeks. This is how we're coming at it. But just to give you a look over the horizon, which I hope will be helpful as you consider the possible benefit of legislative treatment eventually for this burgeoning area. Starting with Uniform Electronic Transactions Act is really good. It might already cover the edge cases that have been identified so far. I think there is probably still some gray in there, and these are the 4 categories that we may change or improve this. I hope we will, but that seem clear so far. Consent and delegation of authority by the human to the agent is one area where, when it's not done right, weird, bad things can happen. When it's done right, very good, efficient things can happen. So having better UX for agents and much better logging of what the consent and delegation was is critical. Attribution is also handled in UITA, but people don't always know whether they're dealing with an agent of another party or that party themselves. So making sure that the legal party who's using the agent's identified, that the two third parties that they're interacting on behalf of, is critical for accountability and for everything to go well. You know who you're contracting with. Apparent authority can be a problem. You're dealing with an agent. I don't know, can it buy $700 of goods for me, or is it only authorized to buy $500? So communicating the actual authority in some way could be helpful, or at least communicating limits. And errors and mistakes. What happens, not if, but when errors and mistakes happen. And in that case, I think the most important thing is for parties to have contracts with each other. And to the extent those contracts are automated, all the better. Google already has an attribution field in their API for Gemini. This attribution field is made primarily for the provenance of data. Because there's a lot of demand for that, as Chairman Western, I think, reflected in his comments. However, it can be used for some of the data is who is the party I'm transacting with. So we could leverage existing fields of APIs to handle some of the things that are needed legally. There's a lot of great best practices already for consent and authorization. A big accept button, making it clear and conspicuous what people are doing. There's a lot of good workflows for authorization that we can just apply to agents, but which are not always happening right now with agentic systems. And that's forgivable. It's a new technology, but they should happen. And then finally, when it comes to agreements, making people negotiate an agreement is very inefficient, especially when we want more automated processes. having existing kind of machine readable agreements that they can choose from is a promising possible approach. Creative Commons is a good example. LLMS.text could be a way to do that. And then there's other more complex things like IEEE, a major international standards organization, now has a specification for machine readable privacy policies. That could be slightly tweaked for machine readable terms and conditions, or agent terms when you're using an agent to do an automated transaction with my system. Bond terms is another good example of standard agreements with a pull-down menu that you can refer to in your deal. And so finally, this isn't just for companies. Although individuals, maybe myself excluded, don't typically use agentic systems to do their kind of personal, household, and family and consumer transactions. That is another thing that's coming online. You'll see over the next couple months a number of blog posts from Consumer Reports Innovation Lab on personal agents that can unleash the power of this technology for individuals and consumers, and can help even the playing field in what should be an open and a fair market. And so for anyone that's interested to contribute to any of the work that I just mentioned, in particular, if you want to look at the Stanford Agentic stuff, if you go to computationallaw.org, we've got a little form here, and you just kind of click, I'd like to see your research, and I'm willing to give you some feedback on it. That would be very grateful. That's my little plug there for feedback. With that, I just want to thank you very much for your time, and to say I'd be happy to take any questions. But the main thing is, I think agents are a now thing. I don't think it's a thing that's going to be happening in a year or two. It's already happening in the economy right now. It is not widely used yet, so there's still time to consider how are they being used, what are the implications. But I would encourage the committee to get your hands on agent systems, learn about them, talk to constituents who are using them now, and kind of get ahead of what's imminently about to be potentially a need for a little further clarity legislatively. Thank you. Thank you.
Thank you, Daza. I mean, you covered a lot of ground there, but I think it was really good stuff for the committee and for those watching. I'm certainly bummed that I wasn't the one that tricked GM into selling me $100,000 car for a buck. Daza, was that you?
I wish it was.
Committee, any questions? Mr. Co-Chairman, please go ahead.
Thank you, Mr. Chairman. I did have one question about you just hit on personal agents a moment ago, and one of the challenges with personal agents, probably several, but one is the coupling the privacy concerns with the continuity of the agent, so that you've got to have some place to privately store your agent in a way where you can continue to interact with it over a long period of time, but others can't necessarily glean what it is that you're up to. So you've got a challenge that I don't believe has really been addressed by any of the major actors at this point in time, because they tend to be storing things server side on their own, or you need to have your own enterprise edition. The quick question is there anybody out there that is ahead on this personal agent concept, where you can have that continuity and the privacy at the same time?
Daza?
Yes, thank you. And I would just say there's two things. Number one, there's a number of open source models that may not be as powerful, are not as powerful as GPT-4o1, but that are very serviceable, especially when you prompt them well. And the open source models that are small enough to fit on a phone or on your laptop are things that absolutely can be used for personal AI. The person there's a few people working on this. The one who I admire and respect the most, and would commend to you to talk to, or to look at how they're looking at it. Their name is Doc Searles, and his wife Joyce have been for the last couple of years working on personal agents, and you'll see some demos of their approach for a consumer first agent. in the blog posts that I mentioned are coming out soon from Consumer Reports Innovation Lab. And so there are people beginning to look at this. The approach to not sharing the data with third parties and to keeping it private and secure for individuals, the clean room approach is to don't use their models. You know, if it's not running on your system, you may not own it. There's a balance there, and I like to use the most powerful models, and I'll take the risk, and the terms and conditions offer some protection. But the clean approach is run the models yourself, and places like Consumer Reports Innovation Lab and others are working to make that simple for consumers to be able to do by downloading an app.
Okay, thanks.
Mr. Chairman, follow up?
No, good.
Well, and Daz, kind of along the same lines, it's about privacy, these agents that you may use for whatever the intended use may be. What my understanding is that OpenAI allows you to keep all your input data. My question is, do you believe that? I maybe that's just me being a little tinfoil hatty here, but I feel I've been really burned by the Facebook, Instagram, where they get to keep all your photos, right? I mean, it's your photo, but they get to keep it too. And so I don't know, maybe it's just me being a little suspicious, but I guess I'm asking you to opine on kind of a gray area here. But do you see that data ownership, all the input data and output data, where do you see that going in the future as this technology evolves?
Thank you, Mr. Chairman. I share your reticence about sharing very sensitive data with these companies that may have other priorities today, and who knows what their positions will be tomorrow, or when they're acquired or go bankrupt. What will happen to all that data? So these questions don't go away in this new context. We've had them in the past. You mentioned Facebook is a great example, and that's not the only example. Having said that, I'm testifying on my own behalf here, but my personal view is that's a deal I've mostly been willing to take because of the amazing capabilities of the technology. There's some risk involved, and I don't share extremely sensitive stuff, but I'm willing to take some risk, partly by reading their terms and conditions and what their current promises are. Also, there's in the terms and conditions, you'll see, like in OpenAI, for example, if you pay the $20 a month, one part of the deal you get is they claim that they won't train their models on your data. So there is some respite there. I run open source models to do the most sensitive kind of client stuff, or if I'm not permitted for under contract or something, or my own common sense to risk having someone else see data, but I still want a little help. I've got open source models for that. I think this could be one area where legislation could be useful. I'm not certain that state by state's the right way to do it, but having some really clear ways that a consumer can know under these conditions, my data is completely safe. Under those conditions, it may be shared. Maybe that changes the price of it or something like that. Could be really useful. It is right now a little foggy to most people what will or won't happen with your data when you use the systems. And so I really appreciate the caution that you reflected in your question, Mr. Chairman. I share the caution, and yet I want the benefit. And so in my case, I frequently will take some risk in sharing the data to get the outcome I want.
You're a brave man, Daza, braver than I. Any further questions, committee, for Daz or for anybody else? I really appreciate, again, was there anything else also in the demonstration that you wanted to touch on, Daza, or any other further remarks?
Yes, thank you, Mr. Chairman. The only thing I'd say is for reasons of time, I didn't go through the live demo of the Agento system, but I will say this, the hypothetical goal that you both, Chairman Rothfuss and Co-Chairman Western, provided to see how the agentic system would work on a conundrum that you'd been working on with tax credits for energy generation and constitutional and other questions around that. I did run that query, and I'll share the outputs with you, but it did, I think there's a lot to learn from throwing it curveball kind of questions like that. I assure you it wasn't designed for that specific question, but it did break up it created a plan, it broke it up into small tasks, and it kind of looked at the energy distribution market, it looked at the constitutional questions, it looked at different alternatives for how you could structure legislation, and put it all together again in a report at the end. So I guess the last thing I'd say is just to close the loop on that. I could say, although we'd hung up by the time it was done processing, it did complete that task. And I think that I'll be happy to share that with you. It wasn't anything you would take and rely upon for your legislation, but I think it does show that these things can be useful. They can be an aid in your process. And if it had access to more information about your energy market and the rest of Wyoming law and the specific case law constitutionally on interstate commerce that you could trip up with the approach that you had with credits and so forth, it can do even better. Thank you.
Mr. Co-Chairman?
Thanks, Mr. Co-Chairman. Yeah, that's great. And I certainly would like to see that and read through that. I appreciate you finishing up that exercise. And Mr. Co-Chairman, I appreciate this presentation today. This is exceptional, and it really gives us insight into the next generation of what we're going to be able to do with AI. And it looks like we're already beginning that next generation. And there's incredible capacity out there that not too many people know about, but it's beginning to be where the state of play in AI is. So we need to know that. We appreciate you organizing these exceptional speakers today and presenting that to us. So once again, thank you for helping us to understand the cutting edge state of affairs.
Yeah, Des, I really appreciate, and the select committee really appreciates your time and all the effort you put into putting this panelist together, give us this demo. I mean, I think this is the kind of stuff that again, whether we take any action, this is the kind of regulation or the kind of discussion that leads to good regulation. So we really appreciate you teeing all this up. Committee, any further questions for Daza? I know we kind of did some shuffling of our agenda there. We still have an important issue pending before the select committee, but want to make sure there's any further questions. And I'm not seeing any. So again, Daza, really appreciate your time, and please do stick around.
Thank you, Mr. Chairman, Mr. Co-Chairman, members of the committee. It's been an honor.
Excellent. Well, Mr. Co-Chairman, I know we kind of shuffled around our agenda a little bit so we could accommodate that great demonstration. We haven't taken any formal action, upon that 25 LSO 0086, the digital ledger filing system development. It's 4:15 now. I would be inclined to dispose of that question now versus trying to do it during lunch tomorrow or the morning. But Mr. Co-Chairman, what's?
Well, I think finishing up with AI, we've got the 2 bill drafts to work through.
Oh, here I am, Mr. Co-Chairman, getting all excited. Thank you.
That's all right. Yeah, I don't mean to give you any expectation that we're ahead of schedule on this one.
Yeah, wouldn't want that to happen.
Yeah. So maybe doing those first, but I do hope we can get done with the other bill draft today. Hopefully it won't take long to act on it.
Absolutely.
And Mr. Co-Chairman, I can give a reminder if we want to go to the consideration of the bill draft. So
do we want, well, I guess maybe, was there any?
Oh, public comment on that.
Yeah, I guess maybe break it up. Was there any public comment on that demonstration? Anything on the Zoom world? I'm not seeing anything, or is there?
Yeah, Mr. Chairman, we have Mr. Maher who would like to comment, and then we also have Carrie Agan online.
Sure. Yeah, let's, Mr. Maher. Let's let him in.
Can everybody hear me?
We can hear you loud and clear.
Oh, great.
Please proceed.
Okay, great. Yes, I'll try to be short and brief. Thank you, co-chairs. What I'd like to do is just take a quick moment to tie everything together and say that the AGI, I concur with Daza regarding the speed and acceleration of the AGI systems. And I should just very briefly note, as you're well aware, as an alum of the Media Lab in '97, I think I've testified before, we had an agents group at the lab, and we were doing these kinds of things back then, just not at scale. And then in 24, in 22 rather, I testified that we're already at the place of general artificial intelligence, give or take a week. So the point here is that what we've got going with what we're proposing for the cryptographic identifiers, seals, and descriptions, and the other act regarding cryptographic signing and all of these things, it really gets to the point of tying together these agents and their ability to ascribe agents to these seals. So dealing with all of these issues of provenance and data privacy with public and private identifiers, we are headed towards being able to have some legislation which deals with all of these issues. So I think we're on track. Your time is precious, so I will concede the torch.
Thank you, Mr. Maher. Committee, any questions for Brendan? Seeing none, thank you very much. Ms. Eggers, am I saying that correctly?
Agan, that's okay. Can you all hear me?
Agan, oh, yes, we can. My apologies. Please,
No,
any
that's all right.
testimony you'd like to share on that demonstration, we'd love to hear it.
Thank you. This is more generalized to the entire topic. Is that all right to do that, sir?
Yeah, go ahead. Please proceed.
Okay, thank you, Mr. Chairman. My name is Carrie Agan. I'm a resident of Buffalo, a retired geologist, and I have 2 degrees in engineering and the geosciences from the Colorado School of Mines. Artificial intelligence is a misnomer, and therefore governance by artificial intelligence is also a misnomer. I'm going to pose a number of questions to yourself and the committee to think about before proceeding further. Again, first, there is no such thing as artificial intelligence. There is no intelligence there in a computer. It can only do what it's directed to do. Therefore, AI can only do what programmers and those directing the programmers tell it to do. It is not the computer or the program directing these things. It is the programmer and those directing them. Period. AI is smoke and mirrors. The computers are calculating for existence. For instance, the probability of the next word you might type in or that it should provide you with. Computers calculate. That's it. They most certainly do not think. Second, because it is the programmers directing the computers, programs directing the computers, it is therefore the programmers and those directing the programmers who developed the programs who are calling the shots. They are ultimately responsible for what the computers do and don't do, and the decisions and suggestions they make and don't make. Where are the teeth in this or any other draft legislation to ensure that those who are responsible actually take responsibility? Third, a lot of people may be willing to have AI direct their lives or some aspect of their lives. There are a lot more who don't. They are perfectly willing and capable of making their own decisions and want to continue doing so. Again, none of this AI stuff is actually needed. Fourth, computers can only do, again, what it's told to do, and also, excuse me, it only knows what it's told or allowed to know. Several speakers today have talked about the programs detecting conflicts of interest quickly. Well, yes, if the computers were allowed to know that information, we're under a heavy blanket of censorship by the government and corporations. Where are the guarantees that these computers will be told everything they need to know before they make a decision? Fifth, there is no need for governance by AI. Why are you seeking to fix things that aren't broken? Why is government constantly, incessantly trying to tell us how to live our lives? And now government wants AI to tell us how to live our lives? Sixth, there is no guarantee whatsoever that our information will be kept confidential, secure, or private. Will this or any draft legislation cover this aspect and provide some reassurance to the public? Seventh, governance by AI will allow foreign actors, including foreign governments, a huge front door, and not only a back door, but a huge front door to direct vast areas of public, corporate, and governmental actions. We're already suffering badly from bias in every sector. This is just allows another means to do so. For instance, academia and medicine. This will accelerate the trend of bias. Excuse me, sorry. Is this really what our legislature wants for us? Legislature? Eighth, this will continue the alarming self-destructive trajectory of the death of critical thinking skills in children and adults by continuing the outsourcing of our thinking to computers and computer programs, thus the computer programmers. Is this really what we want? How will we become little more than monkeys, being told what to do, what to think by computers, actually computer programs? Does this really make Wyoming and America a better equipped people or less? How long before this programming and bias program is turned on healthier decisions, legal decisions, etc., leading humans to give up their natural rights, including our bodily autonomy, to these programs? Ninth, this will decimate even more jobs. This will not create jobs. This will kill jobs. Is the convenience and speediness really worth that? Does Wyoming and America really need to lose more jobs? I believe what this is really all about is two things. One, big tech and their cronies want more money and more control. The perfect way to get that is to sell products and services that are not needed. Second, this is also about technocracy and central planning. How much easier to bring America and the entire world into governance by machines and central planning, which is essentially communism, than to fool us into thinking that computers can really think. Oh, and that computers can do it better than humans. I and many other Wyomingites and Americans believe this is absolutely the wrong direction and urge all of you to stop now. If you and others need more information regarding technocracy and central planning, I urge you to look into Patrick Wood and his excellent website, Technocracy News. Thank you very much for allowing me this time. I appreciate it.
Thank you, Ms. Stevens, for your testimony. Committee, any questions? Seeing none, thank you very much. Was there anybody else online? Clarissa, okay. So we have a couple of different bill drafts pending before us. Mr. Co-Chairman, I mean, we could certainly have David, sorry, Mr. Co-Chairman, go for it.
Yeah, thank you, Mr.
Was there any-
Co-Chairman. I was just going to note we worked these bills in the last meeting up in Sheridan, and one of the suggestions was to rework 149 into 150, where 150 is related specifically to elections, so it's a narrower version of it. But by and large, they're the same bills, and I guess maybe just starting off with a very quick overview from David on perhaps some of those differences, but at a high level, because we've worked these bills for a number of years. And then we do have some potential public testimony, but it's my inclination, unless there's some desire to the contrary, to not spend a lot of time on these bills today and probably continue to set them aside based on
let's have David maybe just at a very broad level kind of walk us through and some of the changes that we made since our July meeting in Sheridan.
And I don't think we did change anything in 149 substantially, did we?
I think it was.
There are some, okay.
David, please proceed.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, taking kind of a look at, and I'm going to do 149 and 150 kind of separate, but they do overlap. And so I'll just kind of highlight the distinctions. First, I'll start with what is different in 149 from when the committee last looked at the bill draft. Primarily, that involves some deletions. On page 3 of the bill, subset or subparagraph B, talking about the definition or when a person engages in unlawful dissemination. We tweaked the audio only version of that and removed some very specific language. And so now it is a bit more general in how it applies and a little bit less restrictive and prescriptive rather on how that could apply to someone. There is a staff comment there just noting that perhaps the committee may wish to consider adding a consent element to address some of the concerns that were brought or mentioned last time with how this might apply to someone who is wanting to proceed with their own synthetic media about themselves and how the existing language, even if you created it yourself, you could still be guilty of unlawful dissemination with the current draft.
And Mr. Chairman, if
Mr.
I
Chairman.
may, the discussion there, it was Senator Ellis that was pointing out the idea of, for example, when you, as structured, if I take a selfie of myself and the AI
Gloss
touches
yourself
it
up.
up for me, which it does, and I thank it for that. In a strict reading of what we have for the definition, that then becomes effectively synthetic media, and it is intended to mislead because I want people to think that I look younger. And
Who doesn't, Mr.
right,
Co-Chairman?
exactly. And so it does become a bit of a challenge, and I think that is an important staff comment to contemplate, is that that's not the intent of the law, but a strict reading of the language would potentially qualify it. So just to clarify that before Mr.
Mr. Hopkinson, please proceed.
Next, Mr. Chairman, the previous version of the bill did have language in there on basically criminal, making it there a criminal component. That's been removed in this new version. And then finally, on the last page of the draft in subsection H, there was some additional language there, adding media that constitutes satire or parody, or is otherwise protected under the First Amendment, just adding satire or parody as exceptions to what this would apply to. And so those are just the primary differences between versions that the committee looked at previously in this version. In looking at the elections in 150, as the staff comment notes up front, it's modeled after, well, last year's and really after 149 that we just looked at. There's a few questions that the committee may wish to consider some on any additions or specifications as far as what it should apply to, just noting there whether it should be limited to candidates for office or potentially other types of elections, whether anyone should be able to file a lawsuit or just a candidate, whether an injunction might be the appropriate remedy. And these are all kind of things that we see in other states and in how they specifically have handled synthetic media in their elections. And then finally, whether there should be a kind of a limit based on the amount of time prior to elections. A number of other states will limit this to say 90 days before an election or something like that. The primary differences between this version of the bill and 149, we see instead of natural person in paragraph 2 in the definition of synthetic media, talks about a candidate's appearance, speech or conduct. So it's specifically references a candidate. I would also note that this places the statute into the election code, which is different from previous version of the bill. And then on page 3 in subsection B, there's an additional line there, a requirement when you're talking about when a person engages in unlawful dissemination, that it be done in the last 2 lines there on 8 and 9, needs to be done with the intent to influence the outcome of any election for public office. So that's just limiting language that it has to be done with that intent. Similar staff comment on page 4 that the committee may wish to consider a consent element. Currently, the language is otherwise pretty similar to what's in the previous bill in the sense that a person who could bring or raise these issues would be anyone who is depicted by or misled by synthetic media would be able to kind of charge this. It may be worth considering because this does kind of create its own method for enforcement. The committee may wish to consider if it would be more appropriate to go through the Secretary of State's office, similar to other election code requirements or statutes. So that may be a change that the committee may want to make. This version still incorporates the potential for punitive damages, exemplary damages, similar to none of that has been changed in this version. So whether or not that's still appropriate in election bill, certainly something for the committee to consider. And then otherwise, Mr. Chairman, it's pretty close to what we saw in 149.
Well, thank you, Mr. Hopkinson. Committee members, any questions? Seeing none, Mr. Co-Chairman.
Thanks, Mr. Chairman. And again, you know, I think the second bill is obviously a narrow version, and for those that might not remember, the original concern of the select committee was providing protection for elected office or elected officers and limiting who had protection down from a full class of the general public was the concern there, that if we're going to pass legislation recognizing that all members of the public should have equal access to protection under the law. And so there was a desire to craft it that way. But then in our previous committee meeting, there was discussion about, well, maybe we could get behind just this more limited protection. So we drafted that out for consideration by the committee, which was the request of the committee. But Mr. Co-Chairman, my concern is that, you know, this is a piece of legislation that we haven't had unanimous consensus on and support and in conversations as we've been drafting and as we've been working on it. I don't think we've achieved that support. And one of the things that we really try and do on this select committee is bring forward legislation that we all get behind. It's always hard enough to get something through the legislative process that every last one of us is supporting. So that's why it would be my inclination probably just to continue to push pause on these, see if new circumstances, new events, new statutes in other states come forward that provide us with some solutions to the challenges or a more imminent need as we come into an election cycle. And we've already been seeing some deep fakes affecting that election, other similar manipulations affecting the election and providing misinformation, but maybe waiting another cycle and contemplating it, whether it's worth bringing up again in the next interim as we know and understand more and see how this plays out in other states where I don't think anyone else's legislation is probably going to do a great job of addressing the needs. So that was my inclination, Mr. Co-Chairman. I don't want to take a substantial amount of committee time to work through these bills if in the end we're not going to have almost full support, if not full support behind it. I don't think we're there yet. So
yeah,
that's where I'm at on it, Mr. Co-Chairman. Thoughts?
Yeah, Mr. Co-Chairman, I would largely agree. You know, we had a lot of discussion. Again, I think that, you know, the issue is very real, right? And the damage that this can cause can be very real. But at the same time, this is a process that's designed around consensus and getting a high enough consensus. And I'm not seeing any of the committee members jumping out of their seats to change positions on this. And so absent any people really changing their minds, I think you're probably right, Mr. Co-Chairman, that unless, you know, consensus has, or we've generated more since our last meeting, it probably is the best use of our time to just postpone further consideration of these particular bills. I mean, again, if anybody on the committee would like to chime in or they have a change of heart, speak now or forever hold your peace.
All right.
No one's jumping for the mics, Mr. Co-Chairman. So
I sense we're in the right place on that one then, Mr. Co-Chairman.
So
I will say, Mr. Co-Chairman, one other thing. And we did have some proposed amendments and we appreciate those from sponsors of the legislation. And again, I think the language proposed in the amendments gets towards some of the technical considerations, which are fair, and we worked on those in the last session, just trying to make sure that we're holding the right parties responsible and that we're not holding parties responsible that are not affecting in any way or transmitting the actual content. They don't have persuasion over the content. So if we do move forward, then we'll have these available, and I'll make sure David and Clarissa, I hope you have copies of these so that we can kind of contemplate them, keep those in the file so that if we start revisiting this next year, that we've got that information available, because certainly respect that. But without,
Mr. Co-Chairman, I do worry that it will take some sort of, really adverse event in our elections for folks to kind of understand that the danger of this issue, but be that as it may. Ms. Co-Chairman, was there anything additional that you wanted to share in this?
No, and I don't know if any member wants to say anything, but if not, that's fine too.
It doesn't look like it. So,
Yeah, without
absent any objection, we're going to indefinitely postpone consideration of these two drafts for next time.
Well, we should see if there's public comment.
You're right.
There probably won't be, since we just, based on what we said,
Yeah,
I'm
we
guessing
just-
nobody wants to come up and
We
just,
just went through
all
a
right,
bit of
good.
public comment, but so,
Do it the right way.
we
That gives us time for
we jumped around. It's 4:38. We still have previous questions under consideration pending before us, which is 25 LSO 0086.
Let's bring it on back.
Mr. Hopkinson, so we went through, we let the Secretary of State's office testify, and we went through public comment. We went through the working group. Mr. Lupien testified.
Yeah, we closed public
Yeah,
comment.
closed public comment. So let's just work the bill. Mr. Hopkinson, if you wouldn't mind walking the select committee through it as currently drafted.
Well, I think we did that too, didn't we?
Did we do that? Oh,
Yep, we're good.
boy, oh boy, my memory is not on point today.
It's all right. It was before lunch.
It was before lunch. Yeah.
Yeah. So, Mr. Chairman, at this point,
Mr. Co-Chairman?
I think it's just a time for a motion. So I'd move 25 LSO 86 working draft 0.7 for consideration by the committee.
It has been motioned. Is there a second? Is there a second?
Second.
It's been motioned and seconded. Committee discussion on the bill.
Mr. Chairman.
Mr. Co-Chairman.
I think there might be some additional back and forth as this bill moves through the process, and we heard some specific concerns and different ways that things could be done. But at the end of the day, I think the bill's in pretty good shape if it were to pass the way it is at this point in time. A lot of the consternation just comes back to a philosophy of what the right approach is. And we've been talking about this issue for over 5 years on this select committee, trying to get to the point where we have the capacity to have an entity, and it makes the most sense for that entity to be the Secretary of State's office, have a Web3 enabled digital identity system for corporations, in this case, basically building the underlying architecture, and then whatever the GUI looks like is fine. We can work that out. This bill moves towards that without any mandates, right? We put in some softer language to accommodate the concerns of the Secretary of State last time, so we don't need any further accommodation there, because the C paragraph makes it clear on page 3 that while there's an obligation to develop this software, there's no obligation to implement it. And so in my opinion, it achieves the objectives that we want in terms of developing out that software, having the opportunity to give it some sandbox testing and use at a smaller scale. That language is present, and certainly provides enough funding at the $2 million level through the Blockchain Center here at the university to work with partners as necessary to develop out a world-class, best-in-class build that I think would revolutionize the Secretary of State's office, but also serves as a puzzle piece that we're looking for to enable a lot of the other things that we are doing. We have to have a central authority that is capable of cryptographically signing on behalf of the state and authenticating on behalf of the state to just get things done. And I hope it's the Secretary of State's office. If we get to the point where we just can't get that done, maybe we look for someone else. I don't know who that would be, but we can go talk to the auditor. I bet she'd say, okay.
Mr. Co-Chairman, I would largely agree. Again, 4 years later, we're exactly where we were.
Yeah.
And despite the exceptional track record and tradition of governance to really not do anything, I certainly determined that we do something, because if we are to think of ourselves as innovators, being stagnant, just spinning our tires, to me, that's not an acceptable default position. To quote the famous country singer Corblund, the truck got stuck.
Yeah.
And by God, we're going to get that sucker unstuck.
That's right.
And I think that's part of what we do as this committee, right? We come up with ideas, we come up with solutions. Maybe they're perfect, maybe they're not, but moving the ball forward is the MO of this committee. And I really think that with the way we have this structured, it's pretty open-ended to allow all sorts of innovative folks to come forward and to contribute and to really take this filing system from a galloping horse to a fast-moving automobile. Because that's what we're trying to do in the short, simplest words possible.
And Mr. Co-Chairman,
Mr. Co-Chairman, please.
This legislation is about making Wyoming business friendly and really taking it to the next level so that we're pro-business. And the idea of objecting to this legislation, in my view, is being anti-business in Wyoming. And it's disappointing to see that out of our Secretary of State and our Secretary of State's office, because that is supposed to be the front door for business for the state of Wyoming. And the idea that a past fight between our Appropriations Committee and the Secretary of State's office has led to apparently a bad taste and a disdain for this legislation as a perhaps a result of it, is disappointing to me. This is pro-business. This is about business development at the cutting edge of Web3 and financial technologies. And I want this to be done first in Wyoming. We know other states have considered it. Right now, I don't know of any other state that's actively pursuing it. So we have our chance of being first. And this is yet again one of those circumstances where first place wins, everyone else, second place is just the first loser. So we need to get there first. This bill's required.
Yeah, Mr. Chairman, I think that kind of sums up exactly where we're at. Yeah, by God, if we're business friendly, we ought to follow up on that. Committee members, again,
thoughts?
Senator Furphy, please.
Thank you, Mr. Chairman. My only concern is, after hearing the Secretary of State, we're putting this blockchain group in a difficult situation. I think they're capable of making some good decisions, but if you don't have the support of the Secretary of State, it's going to be difficult getting the data they need and all of the information they need. That's my only concern, Mr. Chairman.
Sure, Senator Furphy, I can appreciate that.
And Mr. Chairman,
Mr. Co-Chairman.
I absolutely share that concern. I mean, what it comes down to then is respect for the rule of law and a hope that even if the Secretary of State objects to this, that if it passes, that he will comply with the directives of the legislature.
Thank you, Mr. Co-Chairman. Committee members, any further discussion on the bill? Representative Yen, Representative Andrew, Senator Nethercott, I see you online. Is there a?
She's here for roll call.
Okay. She's here to do the business.
All right.
Well, seeing no further discussion.
Roll call.
Elsa, Ms. Shopton, please, do a roll call vote.
Mr. Chairman, this is a roll call vote for 25 LSO 86, Digital Ledger Filing System Development. Senator Ellis,
Excused?
Senator Furphy,
Aye.
Senator Nethercott,
Aye.
Representative Andrew, Representative Singh,
Aye.
Representative Yin,
Aye.
Co-Chairman Rothfuss,
Aye.
Chairman Western.
Aye.
Mr. Chairman, we have 7 ayes, 1 excused.
Outstanding. Well, Mr. Co-Chairman, it's about 4:45. Are we, by God, are we missing anything?
No, we're
Am I?
amazing.
did my T string of a brain forget something here? Or we actually got the business done?
I think we're
Okay.
perfect. Any directives?
Yeah, any committee directives or anything that we're missing? David, Clarissa? Gingerly saying no.
Mr. Chairman?
Any further discussion? Mr. Co-Chairman, please.
Just one other point that, we had the discussion about governance tokens and their relationship to our definitions of tokens in statute with regard to securities. It does sound like we need to do some work there. We obviously don't have another meeting to get that done, so we won't be asking for a bill draft here. But I think it's something, and we'll just point it out to staff as a note that we need to look into that and see, is this a low hanging fruit where we can come up with a simple solution for the near term, or is this something that we need to work on during the next interim? Because I do think we need to revisit from the state's perspective, how the state views digital assets with regard to our state securities law, recognizing that we are not beholden to SEC interpretations of the Howey. So that we're empowered to do that. And the only question in my mind is, can we get it done as a personal bill that we all co-sponsor ahead of session? Or is this something that we end up with the next interim, but one way or another, that needs to be on our task list?
Yeah, Mr. Co-Chairman, I mean, I think that was a really good discussion that we had. And look, I get it. No Secretary of State across the country wants to, butt heads with the SEC, but at the same time, they're not their concern, right? If it's not explicitly in direct conflict with agency rule or United States code, that should not be their priority of consideration, right? It's about the regulation and clear enforcement of our laws at the state level. And I think, Representative, or excuse me, our friend of the select committee, Mr. Lindholm, made that point. I think that's something that we all kind of echoed up here, was that at the end of the day, this is about our laws and the commerce that we are conducting within our state boundaries. And so, maybe let's use kind of an informal poll. Obviously, this isn't a blood oath, but I will not be back, unfortunately, but to the remaining committee members, is if they were to conceptually come up with some kind of draft, I know we need to see it, but again, this is just kind of taking the temperature a little bit. Are we conceptually okay with signing on to, or at least considering some sort of clarification language for our consumptive token statutes? Let's just go down. Representative Singh, you want to at least further entertain this discussion? Okay. Obviously, like my good co-chairman is Representative Yin, Representative Andrew, Senator Furphy. Okay.
And Mr. Chairman.
Ms. Co-Chairman.
And-
What would you say, Senator Nethercott, are she still with us?
I think she is, but we just don't have her video. There we are.
All right, so she's on board to conceptually.
She's got a thumbs up. Perfect. Let the record show.
Ms. Co-Chairman, please.
And, the final thought on that, I don't want to have to put an obligation in statute that the Secretary of State's office respond to requests for decisions. It seems like that's already implied, but that might be something else that we have to do, because I can't imagine a more business unfriendly practice than just denying an answer to a question from a regulator as to how they would regulate a certain interest. And so that's something that we need to find a remedy to. That might need to be a legislative remedy. That would be unfortunate. I hope the conversation we had today leads to a remedy, but if it doesn't lead to a remedy, then the appropriate follow-up would be legislation there. And I think that's a separate bill, really. I think you've got a bill which looks at our open blockchain tokens on one hand and how that relates to securities. But I think on the other hand, then might be an obligation of shall reply by a certain number of days with an authoritative answer, so that we can ensure that we, the state of Wyoming, are not unfriendly towards business, and that we recognize our responsibility to be pointedly responsive as well as responsive in a timely fashion. And if we're not doing that, then we're not meeting our obligations.
Yeah, Mr. Co-Chairman, I mean, if we can't, if our agencies can't respond to basic queries, regarding these kind of issues, I think that's going to have a pretty chilling effect on market participants or potential market participants. And that's, for business friendly, that's That's not good. Trying to think. Was there any other issues that we kind of referenced today, Mr. Co-Chairman? I'm checking my notes here. Yeah, that was kind of the big one. I mean, I know obviously we talked about some of the stuff that the working group on registered agents talked about, and that'll be, I think, the really kick things off for next spring for the next interim. Mr. Co-Chairman.
I actually did have one more. We just need to track and get on our radar the discussion about the matching grant for the blockchain center here at the university. And again, we won't have another meeting to do it, but we need to follow up and track that and work with Joint Appropriations Committee moving forward to explore how we can get additional matching grant funding so that we can continue that role. I think that was about it on my task list. That's
Yeah.
all I see.
I mean, Mr. Co-Chairman, I think that brings up a really good point. Those matching grants are a big deal, and they really do help move the ball downfield. And I commend Mr. Lupian for really stretching those dollars, but the state has to step up and play its part. Obviously, there's a lot of moving parts with the new incoming legislature and what the whims and desires will be. It's hard to know for sure. But we'll certainly find out when session rolls around.
I think that's it for today.
I think that is, again, any further general testimony from anybody, from committee members? All right, for the good of the order, we are adjourned till tomorrow, 8:30, right here.
8:30, right here. Be here. Thanks, everyone. Appreciate you all being here. Appreciate it.